an improper comment, improper statement put before the jury. And even though the court sustained it, Mr. Weinstein and others' ongoing efforts have been to spin a narrative that the state has forced something on one of the witnesses or more of the witnesses. But those particular words, Your Honor, that you put this, you don't know how the state put those words in your client's mouth. It amounts to Mr. Weinstein making a statement, not asking a question, and him making an assertion that the state, in fact, did something that it did not do, which was put those words in your client's mouth. Everybody's heard the testimony and seen what happened. And inasmuch as that statement was an improper statement in front of the jury, and it could be construed by the jury as something, notwithstanding any court's instruction, that they could take as fact, we would ask that the court under 17-875 admonish and rebuke Mr. Weinstein's statements and admonish him to make no further efforts to put such improper statements before the jury. My second motion deals with Mr.
Let's take them one at a time, all right?
Can I respond, Your Honor?
Yes.
There was nothing improper about that question to the witness, Your Honor. I was inquiring about the facts. I'm sorry, I'm losing the word, but the facts that were put forward that the state created. The state doesn't deny that they put those together and gave them to Mr. Wright's client without any input from Mr. Wright. I think it was a proper characterization and it was a question. So the witness could answer that, just as Attorney Love has said. All the evidence is out there. It's all before the jury. The jury can draw what they want from that evidence. So there was nothing improper about that.
All right.
And I actually, well, that's all I'll say.
So I think it was a mischaracterization. It was in the form of a question, but I believe it was a mischaracterization because if we had been talking about the final version that Mr. Sledge adopted, that might have been a fair statement to say, you know, they were put in his mouth, but these were not things that he ultimately adopted, so the state wasn't putting those words in his mouth. So I think it was a mischaracterization. Don't think it goes so far. I mean, you objected, I sustained it. It doesn't go so far as to warrant an admonishment before the jury. But let's try to be careful in our characterizations, even when we are asking questions, all right?
Yes, Your Honor.
Okay, what's your second motion?
Mr. Adams' question to the same witness that the state objected to, but that the jury heard. Isn't it true, and I'm going to paraphrase, that you knew that the state didn't want your client, the state wanted Mr. Williams? Mm-hmm. That's been the lie that they've been, the narrative that has been promoted from the start. We don't agree with it or adopt it, and we certainly don't agree with the idea that we, you know, do these things without a basis for them. So inasmuch as Mr. Adams made that assertion in front of the jury, we do believe that that merits an admonishment and rebuke under 17-875, and we would ask that the court give him one.
All right, and yeah, that statement was essentially, it followed upon another question that was not as objectionable in this way, but that had been sustained. And Mr. Adams, she pretty much doubled down on it and said something to the effect of the state wasn't interested in getting Sledge, they were interested in getting Williams. And that's inappropriate to have asked that witness, and I don't know why you thought that there was any basis for that being an appropriate question, because it would call for speculation anyway. So what's your response to the state's request that you be admonished with regard to that.
Your Honor, it was not a question it was a question that I believed was an appropriate question, given the context of both this witness's testimony and his client's testimony previously. What we'd heard in the narrative that has been put forth, and quite frankly, I believe the evidence has been that the state has been mostly interested in Mr. Williams as a defendant as opposed to the co-defendants, particularly as regards this witness and Mr. Sledge. What has come out and what's been of importance is this meeting that they had on June the 9th, where this statement is made that is beneficial to Mr. Williams. The part about him advising
Right.
Mr. Copeland or Mr. Sledge to take Mr.
Take
Copeland
Copeland
to the police.
station.
And that's left out of any questioning of Mr. Sledge. He is asked, or he is, however it comes out. There's no discussion about that. We're not going to ask you about that, whatever portion of it you choose to believe. And so there is this narrative that's out there that they appear to be interested in Mr. Williams, not so much in the co-defendants. And the fact that all of the co-defendants who took pleas were asked, made, or signed plea agreements where the bulk of the plea agreements, and the jury has heard at least 3 of them previously, the bulk of the plea agreements make specific reference to Mr. Williams as the head of YSL. Mr. Williams did this. There is this narrative out there that and everyone has gotten probation. All of the people that the jury has heard from has gotten probation after they were denied bond, and the state took a harsh position that they didn't need to be out on the street. But the minute they entered pleas, and implicated Mr. Williams in some form or fashion in their plea agreements, then they were released. And so that narrative is out there, and I think that was an appropriate question to ask of this witness who has some knowledge of that.
How does this witness have any knowledge of the state's desires about who they most want to get with regard to the 19 or so defendants that are indicted in this case?
Because he is a defense attorney representing one of the co-defendants who assisted in entering into a plea agreement. He is familiar with the discovery. He made a statement in part of his testimony previously that he knew what the case was about. And he started going down the road of talking about Mr. Williams before there was an objection made and the objection was sustained. And so he does have knowledge of that. He knows about the case. He knows that Mr. Williams is alleged in this indictment and by the state's narrative to be the head of this YSL organization. And he knows that the plea agreements have been to the benefit of the co-defendants who have pled and to the detriment of Mr. Williams.
And every other defendant still on trial.
Well, but he also knows, I asked him one question about, was he in court when he heard the statement that was made by the prosecutor before the plea, made by the prosecutor. It was Miss Lizzie Rosenwasser at the time, where the statement was made that we're interested in anyone who wants to make a deal except Mr. Williams. We're willing to make a deal. And so he knows this. We're not doing this in the blind. He's aware of this information.
I'd like to respond.
What's that? Yeah.
I don't know of that statement that Mr. Adams is speaking about, except Mr. Williams. If he could point me to something, because I wasn't there when she said it. I wasn't even on the case, but I doubt that she would have said it. But if she did, I mean, I can't speak to that. I'd like to see it since he's made that assertion. But the second thing is, as it relates to his assertions regarding the plea agreement, Mr. Sledge, I believe, or either Mr. Wright or Mr. Sledge were cross-examined specifically on whether or not the state asked Mr. Sledge any questions about Defendant Williams. And Mr. Sledge said no. And the idea that we're pushing the narrative when the state itself, as the record will reflect, elicited the testimony about Mr. Williams encouraging Mr. Sledge to take Kenneth Copeland to the police station, belies this argument that the evidence that has been brought out by the plea agreements and by the state's actions somehow or another support this, in my mind, baseless assertion by Mr. Adams in the form of, or in the disguise of a question to Mr. Sledge's attorney. There has been, Mr. Sledge's attorney could have been asked whether the state, whether the state asked more questions about one person than another, but actually he was asked and he testified that the question and answer session was more of a kind of get to know you session, and that when Mr. Sledge began talking about Mr. Williams, the state said, the only thing he said about the state is that the state said, that's not the question I asked you. And when he said something about it appeared to be a hot button issue, he later said, there was nothing that you did that made me say that. I just, based on you not asking him about that, I may jump to that conclusion. So putting in front of the witness, this assertion about the state's intention, because as if it's the state that's on trial and that the state is doing something that is just wrong. Is it your impression that the state don't really want your client, he wants Mr. Williams? It wasn't an effort to solicit an answer. It was an effort to put an assertion in front of the jury that was improper and that can't be taken back. And that has been the entire...
Well, they're going to make that argument.
Yeah.
Regardless, I'm sure they did in opening, and I'm sure they're going to in closing. But I don't believe, Mr. Adams, that there was any kind of a good faith basis to ask that question and to think that was a proper question for this witness to be able to answer. But Ms. Lev, with regard to what you propose as any kind of curative or admonishment, I mean, I don't know what that would be.
I would ask that the court admonish Mr. Adams in front of the jury that the statement he made regarding the intentions of the state as they relate to Mr. Sledge and Mr. Williams were improper statements by counsel, that in those types of statements, the jury is to remember they are not evidence, but that Mr. Adams should not have made that statement in front of the jury.
Okay.
And
So they weren't statements. It was a question. It was just an improper question. And 17.875 talks about statements of prejudicial matters not in evidence.
And Your Honor, it's not, there's nowhere in evidence. It was a statement that was dressed up like a question, but he made an assertion in the form of a leading question. Was it your understanding that the state really didn't want your client, he wanted mine? And the fact that he dressed it up as a question doesn't take, our position is it doesn't take it out of the realm of improper statements put before the jury that fall under 17.875 that merit admonishment at the very least, even if not rebuke, but that Mr. Adams should be admonished about that statement. It was improper, and it should not, similar statements, even in the form of questions or disguised as questions, should not be made about the state's intention, which one, no one else can testify about, and two, it was just wrong to put before the jury, pretending it was a question to this witness.
Your Honor, if I may respond briefly.
Go ahead.
I have this witness on cross-examination.
Yes.
And I'm allowed to ask leading questions. I will defer to the court. If the court felt as though the question was an inappropriate question, there was an objection made, and the court sustained that objection. And I abided by the court's sustaining that objection. This does not fall under the ambit of 17.875. This is not tit for tat, where because Ms. Love was admonished previously, now she's trying to find every opportunity to get somebody else admonished. That's not what this is. Now, I'll abide by the court's ruling, by the court sustaining the objection, but I've stated on the record what my belief was and what my good faith basis was for asking that question in regards to the narrative being put forth from the beginning of this case. and I'll stand by that.
I'm trying to look back at what happened right before that. Give me just a second. Sustained was, it was your observation that the state wanted this plea to go through as much as Mr. Sledge did. The state objected about on relevance and speculation as to what the state wants. Oh, I actually overruled that one. Never mind. Oh, I made it a different kind of ruling, and I said re-ask your question. Based on your conversation with the state, your knowledge of the case, your communications back and forth with the state, your evaluation of the plea agreement you formed, or you observed that the state was just as interested in getting this plea done as Mr. Sledge, wasn't that true? Objection calls for speculation about the state as to whatever his observation is or belief was. It's not pertinent to any material I sustained. And then you followed that up with, was it your observation that the state wasn't really concerned with Mr. Sledge? I think it was with getting Mr. Sledge, but with getting Mr. Williams, which would also have been asking for, what the state wanted or didn't want, which I had just sustained, but asking in an even more pointed way. So it was inappropriate for you to ask that question. With regard, though, to an admonishment, any instruction I give is just going to highlight it again for the jury. So is that really what you want?
Your Honor,
Why don't I just admonish Mr. Adams privately not to pull anything like that again, or you will get admonished in front of the jury? Would that suffice for now?
Yes, it does. Thank you.
Okay. Are there other issues we need to raise?
I just like to
I'll
say,
let Mr. Steele if you want.
Okay.
just before the court, or if you'd reconsider, Mr. Copeland made it clear in his testimony that the police wanted Mr. Jeffrey Williams, that all of, he realized.
Yeah. That's a
So-
different issue though than the prosecution being just about Mr. Williams, which y'all can certainly argue all you want, but that doesn't make that a proper question to have asked this witness.
And just, okay, maybe you resolved it, but you said something I found interesting earlier. I found a lot of things you say interesting, but thrift, T-H-R-I-F-T versus state, seem to agree with the court's, what I think the court was saying. It's 310 Georgia, 499. It's in Division 7, like 6-7. It's a 2020 case. And it seems to say that a question asked is not contained in 17-8-75, but it says pretermitting. So I don't think they reached that issue, but they clearly didn't reach it, as a statement. I just wanted to.
Okay, I appreciate that, and I do think that's correct, and so I'm glad to hear that an appellate court also came to the same conclusion. Thank you. Yes, sir, Mr. Sharp.
Thank you, Your Honor. I know Mr. Adams has not finished his cross yet.
Right.
I also have a short
Okay,
cross-examination. I wanted, and as you know, Mr. Botts was flying solo this morning, and I want to be clear. I'm seeking guidance from the
Okay.
court. There's an area of inquiry that I wish to get into, but I don't want to be accused of opening any doors.
okay.
Mr. Come on, help me out here. Right. Mr. Attorney Wright, thank you. Attorney Wright has testified that there was one specific, and I'm going to have to go up there to see the number. There's one specific, no, not three. There's one specific provision that he asked to be removed, and the state did in fact remove it.
Okay,
Okay, and I'm not going to dispute anything like that. I do not plan on getting into the contents of number 8, but I do plan on asking Mr. Wright if, to his knowledge from the review of the discovery, his client made any such statement to the police and any such statement to the district attorney. And the reason I'm asking that is, and then I'm going to conclude it, so this is not a situation where Mr. Sledge said one thing at one point and it was now disowning what he previously said, but rather it's just a situation where he's never said that.
okay, so.
And that's it, and I'm not going to get into contents of anything, but I just didn't want to be accused of opening the door to the contents.
I think the contents of number 8 are already in front of the jury anyway, because it's one of the factual assertions that Mr. Sledge disputed, and so those were read out, weren't they?
It's very confusing
They
because
were.
one prior version, number 8,
It's not the same as
is
the
not the
ultimate one.
same. So what I believe Mr. Wright what I believe him to have been saying, and perhaps I will confirm by having him point to it when I'm up there, so it won't be read to the jury. I believe he was referring to the part where he said he heard, his client heard someone say, "We caught nut."
Oh,
Add, and then that other number 8 was added in its place. So I'm referring to the original number 8.
okay, I don't know if that was a number 8 or not.
Well,
You'll just
whatever
have
number it
to-
was.
Yeah, you'll have to, because I don't know if he even gave a number.
Okay.
But yeah, that's fine. But I mean, I think that y'all know from, and that's a legitimate question, but I think y'all already know from maybe our discussions up at the bench that I believe Ms. Love made an argument that his knowledge was based on their post-Nutt's death discussions at the condo. And and I may be misremembering it, but I think that was what Ms. Love at least indicated was her kind of basis for putting that in. So if you ask and no, he never made a statement to police, it's then possible that she gets into that. Although y'all, we are getting, I mean, could we focus on what the issues are in this case, please?
Your Honor, when the court permits, there's one more matter that I think I want to bring to.
Okay, so do you have any issue with if Mr. Shart ends up asking, that line of questioning? You're gonna have an issue with that?
My response has to do with what Mr. Wright's answer has already been. I actually didn't quite understand what he's asking. If it'll open the door, I'm not sure what he meant. So if he could clarify so that I can respond clearly.
So Mr. Wright is being very clear, and I think the jury gets it, that his client disputed a fact and it was taken out by the state, which I appreciate. But I think that, heck, if as an attorney, if I heard that, I would be under the assumption that it ended up in the first place, because he must have said that previously and is now disputing it. I'm not going to get into, the state put this in there without ever hearing it out of your client's mouth. I'm not going to get into the dramatics of that. All I'm just going to try to establish is that, to your knowledge, what you asked to be taken out was something that he never said. Not just that he's denying it now, but he never said it.
Okay. Now I understand. So what my response is actually going to entail a question as well, similar. But so in States 452, while Mr. Wright was on the stand, I asked him about what we're discussing now, and he brought up himself. I don't know how number 8 got in there,
Right.
something to that effect. And he never said, obviously, I told you to take it out. He said it was an oversight on my part. But I asked him whether it preceded, whether number 460, that email that was sent at 8:43 on December 27th, whether it was sent in response to States 452, which was sent at 5:06. He said, well, States 5:06 did not have number 8 in it, right?
Right.
And so that part was fine. But then when he gets to, he said the next thing he sees is States 453, which does have, it has a version of 8 in it. But not that exact language.
Right.
As we went back and forth, and he told us what didn't apply and what did apply. What number 8 ended up being was a distillation of that original statement, that it contained only the part that he wasn't disputing. So it wasn't a matter of, and that's a matter for
your
argument.
version is that's what he was saying. I think that could be interpreted more than one way. But what Mr. Shart wants to ask is, to your knowledge from your review of the discovery and knowledge of the case, did Mr. Sledge ever say, I personally know that somebody from YSL killed Nutt, right?
No.
No?
I'm
Okay. No.
I'm getting everyone. I'm confusing
Confused.
everyone by
All right. Maybe.
referring to numbers.
Okay.
I understood Mr. Wright to say, I asked, and this is what the state wanted out. I asked the state to remove something. Okay, and forget about the numbers 8 or whatever. What he asked to remove was the statement that someone said,
We got him bad or something.
got Nutt down bad.
All right.
Okay, regardless of what the number is.
Okay.
And I'm not going to ask him what he wanted to get removed. I'm not going to get into the contents. I'm just
right.
going to say what you asked to get removed to your knowledge, your client never said it, and
Oh, that, okay.
in the first place,
Okay.
and when you were representing him, he never told the state that, he never told the state investigators that.
Okay.
Just so it doesn't appear that it's something that he said at one point and is now,
I understand.
So then the question then is not going to be whether or not his client ever said that statement that is now factual acknowledgement number 8.
Right, it's the quote that got taken out from some much earlier version, that is, I don't know where it is, because there's so many different versions, but we got, that somebody said we got nut down bad or something to that effect.
right, and of course, I'm not gonna say what it says. because
Right,
that
okay, but that's what you want to ask about, but you're, okay.
And so if the court could inquire if Mr. Sharp, because we have labeled them all so that they're not confusing.
Do you know what exhibit this is gonna be on? I mean, I don't know that anybody,
Or just a date and time.
I don't know, do you have the exhibits
do.
available?
And I gave them
for
to Mr.
review?
Sharp, but
All
if
right,
he'll just
Mr.
tell
Sharp,
me.
can you review and see what exhibit number that is? Because I don't know if it's on more than one. All right, and so if he asks that, he's gonna ask, do you know of anywhere from the discovery that might have come from?
Or in his representation, Mr.
Okay.
Sledge ever telling someone from the state that
Okay.
prior.
Which one?
Whatever the quote is.
Yes. Of course, it's in the wrong order. Okay, I know it's in Sledge Agreement Updated 2, sent 1:54 p.m. on Wednesday, December 28th.
All right, that's gonna be, I think, 455Y.
That is correct. 455Y. And under number 8 in 4,
Sorry, but that is that is 453Y. 455Y was the one that was sent on December 28th at 1:54 p.m.
that's
Mr.
exactly what I just said.
I'm sorry, I thought you said 1:45. My apologies. Okay.
So it is 455Y.
Right, and I'm not saying it's not in other versions, I just know it's
I don't
in,
know whether it is
Okay.
or not.
I
but
just know
okay.
it's in that one.
All right. And what number was that, please, sir?
It's number 8,
Okay.
So it's number 8 in 455Y. Okay,
correct. But of course, not number 8 in the final version because it's not in the final.
right.
Okay.
Okay, so you understand what he wants to ask is that, and I don't know what you think that might open the door to or not.
I think
I-
it might open the door to the fact that Mr. Sledge has testified to the fact that he was at the condo with a number of people, one of which has given a statement that Mr. Kendrick and Mr. Stillwell both indicated that they killed Donovan Thomas using this language. We caught that in Nut Down Bad. And the fact that Mr. Sledge acknowledged being at that condo during that time,
Okay.
if he starts asking, and he being Mr. Sharp, asks, did your review of the discovery reveal that your client made this statement, then it doesn't have any relevance, given that, one, it doesn't show up in the final version, but two, if his whole purpose is to find out the basis for the state putting it in here first, then I can inquire further about what his client did say and what his review of discovery did reveal, whether or not that statement was alleged to have been made during a time his client was alleged to have been at the condo with the person alleged to have made it. So if that's his only reason, then that's what I would offer up. It's opening a door into. That's just from hearing what I'm hearing so far.
Once again, I'm not getting into the contents, and Your Honor, to answer the question, of course it doesn't open the door, but I was just doing this out of an abundance of caution, and obviously the state is trying to jump through a door
And
that's
so
not
is your
open.
question gonna be to Mr. Wright, from whatever, however you phrase it, whether Mr. Sledge ever said he personally heard that?
I am going to say, I'm not going to use the words personally heard, I'm not going to use,
All right, what are you gonna ask?
I'm going to say, Mr. Wright, on direct examination, you talked about requesting that a
Something.
part of
Yeah.
number 8 on 455Y be removed, and the state removed it.
Right.
And without getting into contents about what it said, is this something based, and I'm going to get into you're his attorney, you get discovery, is this something based on your review of the discovery that he ever said to the police? And I'm not going to say what it is, I'm just going to say what you asked to be removed, is it based on anything he ever said to the police? Is it based on anything that he told to the district attorney or any DA investigators? And I was just going to conclude it and say, Mr. Wright, so the thing that you asked to be removed, it's not a situation where Mr. Wright, Mr. Sledge allegedly said something and was now going back on it. It's a situation where Mr. Sledge had never said such a thing. And that's it. And I'm not going to say, oh, the state was doing this and that.
Okay.
I'm going to keep it very simple.
Okay.
That's fine, but we've never alleged that the state, that Mr.
Okay,
Sledge.
I think they just want to establish what he just said as his final sentence, that Mr. Sledge didn't one time say it and then disavow it.
Right.
And given that it's not something that has been put before the jury, what it is, I don't know how it's relevant.
Well, I mean, Mr. Sledge's credibility is obviously at issue.
Right. And the
But-
state is
but-
putting it before the jury that Mr. Sledge has disavowed what's been put in front of him. And I'm just trying to clear it up in front of the jury that
It
he's
is,
not.
yeah,
This-
I understand. It's fine for you to ask that question. Do not ask it in a way that suggests that the state has no factual basis for having ever suggested maybe that's something he could
I'm not going to do that.
agree to,
gonna
because
do
then I will let her get into, here's why we said this, okay?
Completely understand.
All right, everybody understand that? That's gonna apply to anybody that might examine Mr. Wright. Okay.
So,
All right, what else?
so Your Honor, once Mr. Okay, I'm not going to follow up. I'll just redirect if necessary. But number 3, Mr. Wright made a particular statement on cross, I think, as it relates to number 3, or it may have been on direct, but I think it was number 3, and Mr. Adams followed up on it. And the question was, you asked that number 3 be changed, and then number 3, the state refused to change it. Now, given that that assertion has been made and has been affirmed by the witness, we believe that the content of number 3, which I think has already been put before the jury because it was
It
played.
has.
I think that the content, just number 3 alone, from Mr. Wright's December 27th, 2022, 8:43 p.m. email to the state, the statement that he makes, the video may have seemed like the issue was gang-related, but it was actually about a girl that Sledge was dating, and Kel started kicking it with her. That was the real issue behind that. Not denying the video, but the real issue was the girl. I think that at this point, the language of what Mr. Wright responds with becomes very important because of the characterization made during cross-examination, which was that Mr. Sledge asserted that number 3 was false, and Mr. Sledge has stated that he feels like it was false, and then Mr. Wright asserted that it was false. But the language that Mr. Wright used to correct that assertion does not, it does not assert that Mr. Watts was not a rival gang member. In other words, it does not dispute any material aspect of it. So the only part that we would be asking to Mr. Wright to tell the jury verbatim is what his response was to number 3, so that the jury can fully understand and appreciate what it is that everybody is saying
Understand.
the state refused to change.
I can make this easy. I'll read that number 3 from Mr. Wright's email out loud to Mr. Wright on cross-examination, and the jury will get to hear it. I'm fine with that.
And on behalf of Mr.
Good.
Williams, I don't have any objection to that. I asked the question, I believe, and it was specifically because Mr. Wright had on cross-examination said that on that one, number 3, he specifically asked that it be either accepted or changed. And so I don't have any objection to that.
Okay.
I think the subject matter of that language is
All
appropriate.
right,
Okay, good, then that means I can get, okay.
all right, sounds good. Anything else? Okay, let's get Mr. Wright and the jury. And Mr. Adams, you
Your Honor,
can
can
come
we-
on up too.
Can we approach really quickly regarding a witness? Hang on.
Yeah. Hold on the jury. Mr. Wright can come on in. Thank you very much. Y'all be seated, and Mr. Adams, you can continue your examination.
Thank you. All right, Mr. Wright, welcome back, sir.
Thank you, sir.
All right. I think when we left off, Attorney Wright, I was asking you, we had gotten to the point where I was asking you questions about the actual plea on the 28th of December.
Okay.
So I want to pick up there. All right. At the end of everything, all of the discussions, the plea agreements, conversations with your client, ultimately, Mr. Sledge entered a guilty plea, correct?
Yes.
And he was sentenced, at least in part.
Yes.
And he was released from prison, from jail, true?
Yes.
All right. Part of his sentence, requirement of his sentence was he had a curfew. Is that right?
Maybe so. I'd have to refer to it, but that sounds
Okay.
reasonable.
10 to 6 sound like what you remember, if you remember that?
Again, if the curfew was in place at the time he first got released, yeah.
Okay. It's fair to say that even after he had entered his plea and had gotten out of jail, he had conditions on him pursuant to his plea and sentence, true?
Correct. And it was always an unknown, is he going to have to appear, testify, and, go through this?
But that was, of course, something that was, and I'll use the phrase hanging over his head. That was a condition that was upon him.
Yes.
The possibility of him testifying, true?
Yes.
And of course, the discussions that you would have had with the prosecutor and with your client, and again, I'm not asking you specifically what you told him, but subject matter is that if he were to testify, it would be expected that he would testify truthfully and consistent with that plea agreement, correct?
Correct.
All right. Now, it would be fair to say, and you tell me if I'm right or wrong, that you would, of course, make him available to speak to either the state and or the defense in preparation for his testimony.
Correct.
And previously with other clients, and I presume with Mr. Sledge, it would have been incumbent upon you, and you would have discussed with him the necessity of testifying if he were to be called in, testifying truthfully, correct?
Correct.
You've heard the phrase before. He's used the phrase, and it's been here in court, where he said he was of the impression that he would be able to get up and testify to, quote, his truth. You heard that?
Correct.
Okay. You knew and you understood, based on the discrepancies that you had with the plea agreement, that his truth might not necessarily agree with the verbatim reading of the plea agreement.
Objection
True?
vague, as it relates.
Sustained.
I'll rephrase the question. You knew that he did not agree with everything that was in the plea agreement, correct?
I understood that he did have issues with some of the factual allegations that were contained in it, yes.
Okay. And so, moving forward then from that period of time, December of 2022, to when the state made contact with you about speaking to Mr. Sledge in June of 2024, you made him available at that time, true?
Correct. Yes.
And if I heard your testimony and the testimony properly, this was a meeting that took place at the Starbucks over in Fayetteville, correct?
Yes.
Would have been yourself, Mr.
We've
Sledge.
gone through
Objection.
who it was.
Asked and answered.
Sustained.
All right. You testified that the meeting that was had with Mr. Sledge at that time was approximately 40 minutes. Is that accurate?
Objection asked and answered.
Your Honor, I'm entitled to a thorough and sifting cross-examination. I'd like to be able to explore that because it has been made an issue by the state in their questioning.
Okay, I don't know that the length of time of the meeting has been made an issue. Just go on to what it is that you want to get to with this witness and questions.
Yes, Your Honor.
All right.
Did you describe in your previous testimony this meeting as a getting to know you sort of session?
Yes, it didn't seem like a detailed question answer preparation kind of meeting. Is more of a feeling each other out, getting to know you kind of meeting, and giving you a general idea of, hey, you're going to be testifying, and therefore, you know, I'll be asking you questions, and so we need to get a sense of each other.
Was there a discussion from the state of, did they advise Mr. Sledge of what they would be asking him?
No, there were general questions again, but it was not, often when you think about prep, witness prep, you think, hey, got 20 questions here, the 20 questions on it wasn't anything like that. It was really more of a introduction to each other, get to know you kind of meeting.
It did not appear to you to be what you would consider a witness prep session.
Correct.
And that was on June the 9th of this year, correct?
Objection answered.
Mr. Adams, go ahead and just focus in on what it is that, I mean, we're all familiar with what he's already testified to.
At any time after June the 9th of this year, and when Mr. Sledge was brought in to testify, did the state ever, in fact, conduct a prep session with him where they asked him or discussed questions they might ask him on the stand?
Objection.
No.
Relevance.
Overruled.
No. That was, like I said, we met the one time, and then we've appeared for trial. And to be clear, we appeared to trial a couple times, but we weren't called, but they did not ask questions or anything. We just sort of waited. Mm-hmm. So again, trial was really the next instance of any communication between the state and my client.
Did Mr. Sledge at any time ever indicate that he would not comport with his plea agreement and come in and testify? Did he ever exhibit any reluctance to come in and testify?
No.
Did he ever attempt to avoid a subpoena or to avoid reporting when he was asked to report?
Relevance.
Overruled.
No, in fact, for us, in our posture, we wanted to make it clear if they need to meet with us, see us, when we need to come in, we were always going to make sure we are there and make ourselves available so that at all times it's clear we're fully cooperating.
During the course of that meeting, you described, and I'm going to use your words, that when Mr. Sledge started talking about what Jeffrey Williams had said about taking Woody down to see the police, that, quote, the prosecutor didn't seem to like that topic.
What I said then were words to the effect, and I'll say it again now, that she made it clear that wasn't what she asked him, which is true. That wasn't the question that I heard her ask him. But ultimately, my observations were that it was a topic that she wasn't asking about. And again, it just sort of raised a red flag for me that, is this a hot topic? There's something to that.
When Mr. Sledge testified that the prosecutor said to him, quote, I'm not going to ask you about that, do you have a specific recollection of that being said?
What I can say is, again, I didn't hear Ms. Love say that, but I do know my client indicated that's what he heard. So we were both present, but we heard things differently. So yes, he has always contended that's what he heard. And again, to the extent that what I heard was not the same.
Did he contend that prior to him being put on the stand? Let me rephrase that question so it's clearer. Okay. You heard his testimony when he testified to that on the stand, am I right?
Yes.
Had he indicated that to you, that sentiment to you, that that's what he heard prior to him coming in here and testifying?
Yes.
I want to Almost done. Just have one or two last questions for you, Mr. Wright. I want to jump back to early December of 2022, when you were having the back and forth with the state
Okay.
in regards to the plea agreement. And if I heard you correctly, that was between essentially the 27th and 28th. Is that right?
Yes.
Do you recall stressing to the state or sending them a message, specifically telling them that you were ready, he was good, Mr. Sledge, was good to take the plea, he didn't want any media, and that he just wanted to get back to his family? Do you remember expressing that sentiment to the state?
I did.
One moment, please. Attorney Wright, thank you. That's all I have at this time.
Thank you, sir.
Thank you. Mr. Sharp?
Good afternoon, Mr. Wright.
Good afternoon.
Attorney
sir.
Wright.
Good afternoon.
May I approach to just see what the witness has in front of them?
You may.
This is 1AX, which was that final. These are just my own little notes. It shouldn't be. These are all just my own notes. Okay.
I'm just going to put these in front of you.
Sure.
So they're handy. Thank you, Your Honor. Attorney Wright, on direct examination, you made reference to identifying a portion of a certain factual acknowledgement that you and your client disagreed with and bringing it to the attention of the state, correct?
Yes.
Well, you mentioned several, but there was one in particular that the state changed for you, correct?
I need you to give me a little more info
Okay.
on which one.
And I'm not going to get into the contents of it, but it's in what's been marked 455Y.
Okay. I'm not seeing 55 for me. One more time. 6.
State's just handing it to me.
Okay.
I'm going to approach.
Gotcha.
That's okay, Your Honor?
It is.
I believe
Okay.
that's 455Y.
Yes.
Okay.
Yes.
Now, we're throwing a lot of numbers at the jurors.
Okay.
Just so we know what we're talking about, 455Y is not the final plea agreement with the final factual acknowledgments, correct?
No.
Okay. On 455Y, on factual acknowledgement number 8 on that document, not the final document, but number 8 on that document, isn't it true that you identified that factual acknowledgement and said that you had some problems with that factual acknowledgement? And I'm specifically the last part of it.
Yes.
Okay. Now, as the attorney in this case for Mr. Sledge, you received discovery, correct?
Yes.
And you were able to see what your client may have said or did not say to any police officers.
Correct.
Okay, and certainly you were representing your client and are aware of what your client may have said or didn't say to any district attorneys.
Okay.
And you're aware, you would be aware of what your client would have said to any district attorney investigators, correct?
Yes.
Okay. The part of factual acknowledgement number 8 that you asked to be removed, and the state removed it, okay? You with me?
Yes.
The state removed it, we agree?
Yes.
Okay, that part that you asked to be removed, from your review of the discovery and from representing your client never said such a thing, correct?
I can say that my client never said or adopted that statement, and that was one of the reasons he asked it to be removed.
Okay, and I understand he didn't adopt it, but to your understanding, he never said it.
Correct.
Okay, and that's why I'm just trying to clarify. That portion that you asked to be removed is not something that your client once said and is now disowning or saying he's changed his mind. It's something that was never said.
Objection asked and answered twice.
That's correct.
Okay, thank you. I just want to talk to you about the timeline of you receiving the plea offer and in actual pleading this case, okay? You received the first version of the factual acknowledgments, you would agree, at approximately 5:00 p.m. on December 27, 2022?
Yes.
Okay, and that was the day before the plea was entered.
Correct.
And as I understand, I'm not going to belabor the point, as I understand, you went to 901 Rice Street, the Fulton County Jail, to discuss the plea offer with your client.
Yes.
Okay, Mr. Sledge. And do you recall how long you met with him that day?
Now that I don't know. It would have been long enough to make sure we're going over things for me to get a good idea of what his response would be to our conversation and the things I was going over with him. And then at some point I would leave, and then, of course, as I said, later prepare a response email to the state.
And this meeting with your client, was this you were in the attorney booth at 901 Rice Street?
Yes.
Okay, and as an attorney, or when you met with Mr. Sledge, you were on one side of the booth, there's a glass.
Objection, relevance is to.
I'm discussing their ability to go over this document.
Overruled.
There's a thick glass barrier in between you and Mr. Sledge for this meeting,
Correct.
and he's on the other side of the thick glass, correct?
Correct.
And of course, you have to talk loud, but
Yeah.
you can hear each other, correct?
Correct. And let me, at least so you know, because this is some time ago, I'm assuming I was, again, because we are almost always in the attorney booth. We get a little key, we can unlock it, we can go in. We can also hand documents back and forth.
Right.
That is my recollection of how I met with him, which meant I would have been able to hand him a copy so he can read it, I can read it, at the same time, and go over whatever we need to go over. I'm sort of stating it because it's so long ago. Is it possible that I just saw him through one of the more window only kind of things where I could not have handed him stuff? Possible. I don't remember that. I remember being in the attorney booth.
Okay.
But
So
I just wanted to point out that, yes, we can talk as well as hand stuff to each other to review.
Well, let's let the jury know what we're talking about here.
Yeah.
So if the attorney booth, if someone's in the attorney booth, if it's being used, if it's occupied, you can use a visitation booth, correct?
Correct.
And that also has thick glass in between you and the person you're speaking to, correct?
Yes.
And the main difference is there's no pass-through in those
Correct.
booths.
We
Okay.
can, all audible stuff's the same, but you just can't pass stuff back and forth.
Okay. And of course, when you met with him on the 27th, met with Mr. Sledge on the evening of the 27th, you had whatever version of the plea agreement was in effect at that point, but not the final version.
Correct.
Okay. All right. Could you refer to 1AS
Okay.
for me?
I have it, sir.
Okay, thank you. You would agree that in the negotiations with the state, your client pled to count 1, which was conspiracy to commit Rico violation, correct?
Yes.
And he was facing 15 years to serve. He was sentenced. The agreement was 15 years to serve on probation, correct?
Correct.
Okay. And then count 30, he did plead guilty, and according to this agreement, sentencing was withheld
Yes.
and would be dismissed if he fulfilled the agreement.
Yes.
Okay. At this point, sentencing is still withheld, correct?
Correct.
And the maximum he's facing on count 30 is 15 years, correct?
Yes.
Okay. So right when he testified earlier today, he had a 15-year sentence hanging over his head as well as the probation.
Correct.
Okay. And so his maximum exposure is 15 plus 15, correct?
Yes. I mean, technically less, we'll say any time he's already ticked off since the agreement. But generally speaking, it's 15 plus potentially another 15.
So, and at this point, if he's done a year on probation, it would be 29 years instead of 30 years.
Correct.
Okay. Now, you indicated in your review of the final plea agreement, there was one factual acknowledgement that you testified you missed, correct?
Correct.
Number 8 on the final agreement, you missed.
Correct.
And, well, I'm not going to ask you to speak on behalf of your client, but you missed it.
Yes, I can only say that I missed it, and had I seen that, I would have immediately, because it was of a certain subject that from the very beginning we had sought to exclude from this. But ultimately, for whatever reason, we missed it.
Okay. Can you, in sentencing acknowledgments, number 5 on that final agreement, defendant's sentencing acknowledgments,
Yes.
this final plea agreement between Mr. Sledge and the state, as reviewed by yourself and Mr. Sledge, indicates that your client is facing as much as 35 years in confinement. Isn't that correct?
Correct.
That's what the agreement says.
Correct.
Okay. In fact, he's facing 30, maybe 29.
Correct. It would have been a max of 30. So 35 was incorrect.
Okay. So,
Your Honor, I object to the characterization, the language, I'd object to the characterization, and I don't want to speak further, but the question was posed whether it said he faced 35 years, and that is an incorrect characterization. I can,
Okay, do you want to rephrase?
does the document say that if your client does not fulfill the obligations of this agreement, it may result in defendant being sentenced to serve as much as 35 years in confinement in the Georgia Department of Corrections?
That is what the document indicates.
Okay, is that your client is facing 35 years?
I think it would be a more correct statement to say 30, but point is 30 or 35, a whole lot of time.
Well-
But yes, I think the correct number is 30.
All right, you're making my point for me.
Gotcha.
You signed an agreement where your client was facing, you and your client signed an agreement saying that your client was facing 35 years.
Correct.
And he was really only facing 30 or less.
Objection, asked and answered.
Yes.
Sustained.
Your client, on that final agreement, there's a word that's crossed off and initialed by your client, correct?
Yes.
Okay, begin was changed to being. It's just switching the letters, right?
Yes.
Okay. And that was crossed out and written and initialed by your client, correct?
Correct.
All right, and you've reviewed the video tape. You were in here when the video was played
Well,
of your
yeah,
client taking a plea?
I was there.
Okay. That was something that Miss Love caught and instructed Mr. Sledge to cross out an initial, correct?
That sounds correct, yes.
All right, that wasn't something that was caught by your client.
Correct.
All right. Okay, Mr. Wright, you, in addition to what I first asked you about number 8, the portion of number 8 that you pushed back on the state and they changed, you also pushed back to acknowledgement number 3 on the final plea agreement, correct?
Correct.
And Your Honor, may I go back first?
Yeah.
Okay, and number 3, which you pushed back on, regarded the video that your client made with Quindarius Zachary, where he was, we'll say, threatening a gentleman by the name of Kelvin Watts, correct?
Correct.
Okay. And you're aware that the factual acknowledgement indicates that your client, while associated with YSL and to support and express loyalty to YSL, made this video.
Correct.
And it indicates, the acknowledgement indicates that the video was made on behalf of YSL, correct?
Correct.
Okay.
Your Honor, I'm going to object to characterization.
Sustained. I mean, if you read it carefully and then rephrase.
On behalf of YSL, defendant threatened to harm a person named Kel.
You can ask that.
Okay. But the acknowledgement indicates that on behalf of YSL defendant, that would be your client, Mr. Sledge, threatened to harm a person named Kel, correct? That's what the acknowledgement says.
Yes.
Okay, and you pushed back on that and you sent Ms. Love an email, correct?
Correct. Actually, we began taking issue with that characterization from the very beginning. And this was, I think I testified, an example of where we felt one way, the state felt another, and that was one of the examples where it was not changed.
Right. Okay. Do you have the emails? Actually, this might be.
460 is right here.
Do you have 460 in front of you?
Yeah.
No.
462, 461.
He-
One moment.
This is the only 460.
Ms. Love gave me this one.
Oh,
I'm going to
okay.
approach, if Your Honor will allow. I'm handing you what's been marked as 461.
Yes.
Going to read to you from your email what you said about acknowledgement 3 to Ms. Love. And this email was sent on December 27th at 8:43 p.m., correct?
Yes,
Okay, and this is the night before Mr. Sledge entered his plea, correct?
yes,
Okay. You wrote regarding number 3, the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating, and Kel started kicking it with her. That was the real issue behind that. Not denying the video, but the issue was the girl. Is that what you
yes,
wrote? And is that verbatim?
yes, that was verbatim.
Okay, so the point you were trying to get across is you're not denying that your client, Mr. Sledge, made the video,
Correct,
and you're not denying that he had an issue with Kel,
correct,
but that issue was about a girl.
yes,
And you ultimately, the state was unwilling to change that factual acknowledgement in the plea agreement, correct?
correct,
They were unwilling to take out that it was done on behalf of YSL,
correct.
and they were unwilling,
Your Honor, my objection is vague when the question is they were unwilling to take out that it was done, and earlier Mr. Sharp referenced video, if he could just clarify what he's saying.
Sustained.
okay, they were unwilling to change the factual acknowledgments on your client's plea that he was to sign the next day, right?
Well, again, some changes were made, but as to that specific one,
I'm talking,
that was one example of where they were not willing to change it, even though we had a difference of opinion as to what it was about.
and,
So the it is still unclear, so.
and
if you-
factual acknowledgement number 3, I'm sorry, yeah.
Okay, I,
Yes, my objection was to, could they specify what it we're talking about in terms?
and it may help.
Factual acknowledgement number 3, which relates to the video that was made
Yes,
with your client and Mr. Zachary in it, correct?
yes,
Okay. The state was unwilling to change the language that it was done to support and express loyalty to YSL, correct?
correct,
And they were unwilling to change the language that it was done on behalf of YSL.
correct.
And Your Honor,
Yes.
again, I object.
You can
as to
clear it
characterization.
back up on redirect, or are we already? Yeah, that was,
I haven't
you
done a
still have redirect, so you can clear it up then.
They were unwilling to change the language where it said, wherein on behalf of YSL, defendant threatened to harm a person named Kel because of that individual's association with a rival gang. They were unwilling to change
All
it,
right,
right?
all right, I think that the state's objection is a valid one, and I don't know if you want to, if you need direction, but why don't y'all approach?
Okay, Attorney Wright, do you remember at this moment, in your email, you did not indicate specific changes that you wish to have made, correct?
Uh,
I'm going to object. William, let me
Actually, in my email, the way I even described I put, here are recommended changes, and then I went number by number, all the way 8 through 13 for
Okay.
the agreement I had at the time.
I get it. It's not like you went through it like you do in Microsoft Word and mark it with red or anything like that, like an editor would, correct?
Correct.
Okay, but the point you were conveying in that email was it was not gang related, correct?
Correct.
And it was over a girl.
Correct. As to that issue number 3.
As to number 3. Okay. And ultimately, the final version of Mr. Sledge's plea agreement includes language. You would agree that it includes language that indicates that the video and the making of the video and the threats were gang related.
Correct. That number 3 is an example where there was not a meeting of the minds with the state, and that's where they did not remove the information, consistent with what we were suggesting be removed.
And the gang related versus a girl was where the meeting of the minds was not happening, correct?
Correct. I mean, ultimately, the state included sort of both things in there where we were saying it was really about the girl.
Right. And you told Mr. Sledge that he could explain this later to a jury.
Objection, Judge. One that asked, answered, and province of attorney-client privilege.
Then attorney-client privilege.
Okay. Mr. Wright, from your dealings with Mr. Sledge, you are aware that Mr. Sledge did not completely agree with factual acknowledgement number 3.
Objection asked and answered.
Sustained.
On the date that he pled, he did initial that factual acknowledgement, correct?
Objection asked and answered.
Your Honor, this is the first time I'm questioning this
I
witness.
know, but lots of other people already have, and we've gotten that information at least a couple of times.
Okay.
I mean, you're welcome to ask whatever it is that you were leading up to.
I believe on cross, you indicated that in negotiations, you can't have everything, and sometimes you have to live with some things, correct?
Correct.
And your client initialing number 3, even though he didn't completely agree with it, is an example of having to live with things, correct?
I think I previously did state that number 3 was an example where there wasn't a complete meeting of the minds, but his choice was to either walk away and proceed with trial or enter into the plea agreement.
To go home, Mr. Sledge would have to live with that as part of the negotiations, correct?
Objection, Your Honor. That part is asked and answered. And
Sustained.
All right, here's my question. Is it fair that Mr. Stillwell would have to live
Objection,
with
Your
your
Honor.
client?
Asked and answered.
No.
I'm sorry. That is not what I meant to add. Objection, relevance, and improper question. Is it fair that Mr. Stillwell will have to do anything is an improper question for this witness. So forgive me for.
Sustained.
Was Mr. Stillwell a party in these negotiations?
Objection, that is, again,
I'll permit that question.
Was Mr. Stillwell a party in these
No.
negotiations?
And-
Was your client signing a factual acknowledgement that wasn't true? Is that something that Mr. Stillwell should have to live with?
objection, one,
Sustained.
The signing of these incorrect factual acknowledgments, you would agree that it affects more people than just
Objection,
Mr.
Your
Sledge,
Honor.
correct?
Overruled.
I will state this. Any person in a case where there are multiple defendants, once they enter into a plea agreement that includes certain factual stipulations, that can impact all the defendants, not just themselves. So, to your point, that yes, when Mr. Sledge was completing his plea, his focus was on him. However, there are effects or ramifications that could affect others.
And your
And-
focus
and Your
was,
Honor,
and
my
your focus
objection-
was
Hang
on
on just a
him.
second, hang on.
And my objection was to the characterization of the incorrect or improper factual acknowledgments. So the answer, I think, sort of dealt with, but my objection was that that was a mischaracterization or improper characterization.
Was
All
factual,
right, well,
was,
the jury's heard the testimony, so.
was factual acknowledgement number 3 completely correct from your client's perspective?
We indicated that we took issue with some of number 3. Some of it we were acknowledging and some of it we took issue with.
And he initialed it and he got to go home.
Correct.
Objection. I
And
didn't ask
it affects these other gentlemen back here, correct?
ask the answer.
Sustained.
No further questions.
Okay, does any job questions, Mr. Williams or Mr. Harvey? Okay, all right, anybody need a break before we do redirect? Okay, let's take a quick kind of 10-minute break, try to be back here close to 3. Yes.
Okay.
And Ms. Love?
Thank you, Judge. Mr. Wright, you were asked on cross-examination by Mr. Shart, I believe, regarding factual acknowledgement number 3 that was contained in the final plea agreement that your client signed. Do you recall that?
Yes.
I'm going to ask you whether State's Exhibit 452 Yankee, which was sent at Tuesday, December 27th, 2022 at 5:06 p.m. as indicated by its label, was that document, the document that preceded the email in 460 Yankee from you dated December 27th at 2022 at 8:43 p.m. I'll let you look at that. Paying particular attention to number 3 in State's 452 Yankee.
Yes, it does appear to be number 3 in Exhibit 452 Yankee. And wherein, on behalf of YSL, defendant threatened to harm a person named Kel because of the individual's association with the rival gang.
Now, exactly what did you respond with relation to number 3 when you sent that email in 460 Yankee?
Objection. That's
Your
been asked and
language.
answered.
What'd you say, Mr. Adams?
Asked and answered.
I'm
John.
gonna allow some leeway.
Go ahead.
In 3, I said the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating, and Kel started kicking it with her. That was the real issue behind that. Not denying the video, but the real issue was the girl.
On any part of 460 Yankee or any other communication you made with the state, did you ever assert on behalf of your client that Kelvin Watts was not a rival gang member?
No, I did not go into.
Oh, no,
No.
okay. And
He can explain his answer.
Your Honor, I don't mind explaining, but I wanted to ask, with the court's permission, certain questions that are frankly binary questions, yes or no, and then if he could be allowed to explain, I would
Okay,
just
well, he
like.
said no, and he was
Okay.
about to explain, so you may follow that up your no if you want to with something else.
Go ahead.
I was simply going to say no, but again, the whole point I was trying to make is that it wasn't, from our perspective, really a gang-related issue. It was a girl-related issue, and then ultimately, you did change it. However, the change ultimately sort of included both. That it's a girl issue, but you also kept the fact of some of the YSL and gang contention, and that was just what I would say is sometimes in negotiations you agree to disagree about, what was at issue.
Okay. I'm going to ask you the next question. Did you ever indicate in any way on behalf of your client that your client was not associated with YSL as stated in the first part of Section 3 of 1AS, the factual acknowledgement?
There has never been a time where I've ever contended or represented to you that my client was not YSL.
Okay. And is there ever any indication from you through your client from your client through you to the state that the portion that says where a defendant brandished a weapon used in a drive-by shooting is incorrect, inaccurate, or false?
The answer is no. And further, again, we took no issue with the video. The video is what it is. The issue was just, we were saying sometimes what the motive was. The motive was a girl-related motive, not YSL. Yes, he may be YSL, and yes, the video he does.
I'm going to object.
Hang on just a second.
I'm going to object to the response that he may be YSL, that invades the province of the jury.
Your Honor, we're talking about his.
Overruled.
Okay, go ahead.
Maybe, again, it's contended he's YSL. Maybe, and the video is what the video is. We were simply taking issue at the motive or why the video ended up being created had more, it was focused because of this girl situation between two guys.
Okay.
The fact that Kel or my client or whoever they are was a secondary and what we said not the primary issue.
Okay. Did you ever indicate on behalf of your client in any fashion, whether in 460 or some other way, that the portion wherein on behalf of YSL defendant threatened to harm a person named Kale was false?
No.
All right. All right. So is there any statement contained in State's Exhibit 1AS, Section 3? Is there any portion of 1AS, Section 3 that your client, through you, contended was false? At any time that you conveyed to the state?
The part which says that ultimately his actions in the video.
Wait a minute. Where's the word ultimately in that?
Okay, well, no.
Sustained.
Okay.
He's
Okay.
trying to explain it.
Okay, I'll just start by reading and then I'll pause and explain the part. While associated with YSL, comma, and then here's the part, and to express support and loyalty to YSL. That part is, again, it was not a gang motive. That was the part that my comment would take issue with, that he wasn't shooting this video or making any comments or doing anything. This was about the girl, not about trying to support or express loyalty to YSL. Now, the rest of the, quite honestly, the rest of it is essentially just describing the video. It's correct. And then ultimately, at the very end, where it was added, had begun a relationship with defendant's ex-paramour. That was correct. So the only issue was an inference that it was in the furtherance or in support and express loyalty to YSL. That was the only part that we took issue with. So that's where, when I say sometimes there's something where we agree, but also part of it disagree. That was the part of disagreement.
And to not split hairs, but did you at any point say in your email or anywhere else that that part is factually incorrect?
No, but also understand, my email came the day before. As we started getting into these later versions, I was here in court. I wasn't sending emails. At that point, we were communicating verbally back and forth because we were sort of both here. So, but the point being is, that was something that my recollection is, hey, we changed it to the extent we're going to change it, and that ultimately you weren't going to change it further or, eliminate that. So my client, as I think testified to, will say, look, some parts I may not have liked, and guess what? When asked, I'll explain it. But ultimately, I don't want to not do a plea. I want to get the plea done so I can move forward. And that's that point of compromise.
Thank you for explaining that. All right? Your Honor, I would also at this time ask the court to conditionally admit 452, 460, and 453, not for publication at this time, but subject to additional restrictions as the court sees fit. And we can discuss off
All right, well,
outside the presence of the
I'm
jury.
not gonna conditionally admit them. If we wanna talk about them more, we can talk about them more.
Yes, Your Honor, thank you. While you were on cross-examination, you testified that some of the factual allegations that were contained in the final plea agreement were not ones that you had agreed to. But on direct, am I correct that you said number 3, you asked to be changed and it was changed, but not exactly like you wanted? Mm-hmm. And then number 8 was one that you said today that you missed back at some point when you were reviewing the document.
That is correct.
Okay.
I have said today that number 8 was missed.
Okay.
And a review of it versus our earlier comments to you, they can't be reconciled. I mean, in other words, it's clear that that was not something that we would have anticipated. In other words, it was something we objected to and wanted removed. Ultimately, it reappeared in that final version. We did sign it. Again, I'm not taking issue. We missed it. And unfortunately, had I seen it the day of, I would have paused, stopped everything, and said, this is a hard stop. We got to figure this out.
We'll come back to that in just a moment, okay? Other than number 3 and number 8, do I remember correctly that everything else your client through you acknowledged was
Objection, Your Honor.
accurate?
Asked and answered.
Sustained.
When you spoke of some of the factual allegations, were number 3 and number 8 the only 2
Asked
you
and
were?
answered.
I'm not,
Sustained.
outside of what's contained in the final 1AS. Is there any other thing?
From the very early things that we said, hey, this is not accurate. And then I'm thinking, where'd that come from? But I went back, I realized it was there. How we missed it, how I missed it, I don't know. But apparently I did.
If I show you number 8 on 455 Yankee, an email dated December 28, 2022 at 1:54 p.m., are you able to recall whether this was a document that you reviewed?
If we, okay.
Because I can't have you read it.
No, I'm not going to read it.
Okay.
But what I was going to say is, having read it, ultimately, only the very final part, the last sentence, really the and then everything after that is the only thing we would have asked to be removed from this paragraph. So essentially, you could say almost the last 2 sentences.
And so, $455 number 8 used to move.
Right.
So this, we believe, is a proper line of inquiry, and we'll try and keep it as concise as we can. So, may I continue?
You may.
So, Mr. Wright, when you speak of the change you requested on number 8 of 455 Yankee, does number 8 on 456 Yankee, is that the difference, and is that the line that you're referring to that appeared in the final version?
Well, they are two completely different statements.
Right. And does 456 Yankee contain the line that is now contained in the final version?
No, what I can see is that in 455 Yankee, where item 8 in that document was the one we had been talking about, and we took issue with the last, that wasn't confusing.
Not at all.
Okay.
And what I was asking you is that in 456, that line in 456 Yankee, is that the line that appeared in the final version?
It did.
Okay.
And again, I'm not sure how we missed it. I think because I'm thinking, and again, I can't speak for my client, I can only speak for me, that we were still going off the last thing we had seen. Honestly, I know this final version got emailed to me. I'd be interested to know, just to be sure, what time the plea happened versus this email, because that would make sense as to if I didn't see this last version email before we ended up taking the plea. And again, I'm not saying it did happen. I'm just saying I'm trying in my mind to figure out how we missed that. How did that happen?
And as you were asked on cross-examination about your understanding and your client's understanding or initialing of each of these acknowledgments, was there any acknowledgement other than 3 or 8 that you ever felt you needed to explain,
I don't think this particular question's been asked before.
that you ever felt you needed to express to the state, my client may need to explain these further?
I know that I expressed to the state that at some point my client.
Your Honor, I'm sorry. I'm going to object because I believe that answer calls for something that invades the province of the attorney-client conversation
when-
relationship.
Not when he expresses it to the state.
Overruled.
Go ahead.
But she indicated.
I believe, because at some point it was stated to the state that explanation may be necessary. I don't recall whether we itemized exactly which items were going. I think it was a general statement that, hey, we're signing it, we're agreeing to it, but some of this may require explanation. And at the proper time and place, i.e. if he's called to testify, he's going to want to be able to explain the answer.
Okay.
So I think that generally, without going into any detailed conversations with my client, but that's generally what I recall we were communicating with the state to say, we're signing, sign us up, we're initialing, we're going forward, but some of these things, because there are a couple things in here, may require further explanation, and when asked, he'll have a chance to explain.
Were any of those things inclusive of any other acknowledgement or understanding besides the two that you already pointed out? And if you need,
Could
here
I
it is.
have the final initialed?
I think you,
Because I think your question is going to that. I just want to,
do you have 1AS in front of you?
455.
1AS, what's that?
No, this is 455Y. I think at some point. Reviewing this, 3 and 8 would be the only ones that I believe he would have, I'll strike that. 3 and 8 were the ones that there seemed to be issues that may require explanation.
Okay.
Just 3 and 8.
Did you were asked on cross-examination whether at any point the state asked to sit down with your client. Did you perceive the November 20th, the November 2022, the November 30th, 2022 email from the state as a request to sit down with you and your client?
Well, it was a proffer offer, so yes, that would essentially be your communication to see about having a sit down with my client. And I think I indicated I received it, but we did not respond until middle of December.
Okay. And that response, did it include any agreement to sit down with the state?
No, it actually was simply saying, why don't we talk about a resolution?
Okay. And as it relates to the questions on cross-examination about the November 27th email and the November 28th emails and where you were when you were able to review them with your client.
You mean December 27th?
Did I say November? Yes, I did
Okay.
mean, thank you. The December 27th and 28th correspondence. At that time, were you and your client aware that you all were not the only people who had yet to resolve your cases?
Correct.
Well, the question,
Overruled.
having known me personally for as long as you've testified you have, did you feel that comfortable enough?
Hang on. Relevance? As to what he felt? Yes. What are you, finish your question so I can,
Because the question,
what was the other one? I'm sorry.
Mr. Wright's thoughts about this
I don't
Do you
have any.
maybe rephrase?
All right, I'll rephrase. Did you were asked on cross-examination about receiving communication and plea offers, plea agreements on December 27th and 28th and meeting with your client at the jail and in court. Do you
Okay.
recall those questions?
Yes.
At the time that that was going on, did you believe or did your client indicate to you to express to the state that you needed maybe any additional time to go over those agreements?
No, at that time, we were very eager to ink a deal and resolve the case. And ultimately, that's how the 27th happened in the evening, as well as once we show up to the courthouse, how on the 28th, we were trying to iron out an agreement, which we ultimately tendered to the court.
Were you or your client through you ever given the impression or led to believe that if you did not ink a deal on December 28th, it would go away?
No, I don't think there was ever a sense that we were given a deadline. It was, hey, now or never. I think it was just a matter of he's expressed. He had different concerns and different motivations. So again, not speaking for him, but he seemed very eager to ink a deal if a deal could be had on the 28th.
Okay. And you were also asked about your desire or willingness to go to trial. If your client chose to go to trial rather than ink a deal, regardless of the financial arrangements that you had made, would you have continued to represent him?
I hate to say I could not have afforded to stay on the case and to go to trial, because a trial of this length would have bankrupted me.
Okay.
I mean, there's starve me. I don't know what's the word, but ain't no money being made when you're in a courtroom, and if you're not getting paid for being in the courtroom, there just ain't no money.
Understood. Without getting into what you told your client, would you have made efforts to arrange for him to have suitable or to? Okay. I'll withdraw.
All right.
All right. Did you ever move to withdraw in this case?
No. Again, that's something that would have come later, depending on the choices my client made.
Okay.
And because his choice was to get this plea done and to execute it, that never became a ripe kind of consideration.
You were asked on cross-examination a number of times about your client's sentence. I want to show you what I've marked as states 463, and a copy of which has been, not as it's labeled, but the certified has been provided in discovery. If there's anyone that wants to see it, I'm just giving the copy to the witness.
Okay.
463 Yankee. You were asked on cross-examination whether count 30 was held open until the end of this initial trial. Do you remember that?
Something to that effect, yes.
And do you have any memory of it being necessary for your client to be sentenced on count 30 as a result of the way that that particular count had to be filed with the clerk of court?
Actually, we put creative language in there where if he sees his cooperation through, we could actually be in a position to withdraw his plea on that count, and then it would be null pros. So one of the benefits is count 30 will go away, and then he'll just be on probation for the primary count. So that was, I guess, one of the incentives in this agreement was, I guess you now have both ends. The incentive that that count could go away, or the deterrence that, hey, there's a hefty sentence if you go afoul.
And does 463 accurately reflect your client's final sentence that he was given that day, in addition to, or under the restrictions of 1AS, the plea agreement?
It does.
Okay. And so would you please tell the jury what your client was actually sentenced to on that day?
Your Honor, I'm going to object. That's actually been asked and answered previously.
Well, I haven't seen the document to see what it says, but it seems to me, at least the implication is, no, it hasn't. So, I don't know. Do I need to see the document?
I can show it to the court. Now, passing to the court, 463 Yankee, I ask the court to pay attention to the sentence. I'm going to walk around. You're welcome.
Okay. No, I don't overrule.
Thank you, Judge. Would you please tell the jury what your client's ultimate sentence was?
Ultimately, the sentence that I'm looking at now indicates 15 years to serve on probation to count one,
Yes.
and then 15 years to serve on probation to count 30, consecutive to count one,
Okay.
which would be 30 years of probation. And once this, going to the third page, which is the
Yes.
continuation,
Please do.
that if the special conditions outlined in this sentence are satisfied, and there's I won't list them, but there's a few of them, but ultimately, he would be allowed to withdraw his plea as to count 30, and count 30 would be non pros. That's a Latin way of saying dismiss. So that he would only be standing on his sentence for count one.
Okay.
And I know someone had, since I'm here, had asked me about whether there was a curfew, and I do see where there's a curfew as part of this sentence.
Thank you. Wrapping up with the last three questions. You said that you were asked on cross-examination and you testified about whether or not your client initially was charged with the murder of Donovan Thomas and whether the police dismissed those charges. Do you remember that?
I remember
The question.
the topic, coming up,
Okay.
question coming up, yes.
And do you know whether it was the police or the district attorney's office that declined to charge your client?
Yeah, I can't say I've known police to ever have that authority or make those decisions. It was my understanding it was the Fulton County DA's office who made the decision not to pursue those charges any further.
Okay. And the last question is, you spoke earlier about representing your client in his 2015 case.
Okay.
And entering that plea in his best interest under Alfred. Do you recall that?
Yes.
And at the time that you represented your client on 22 SC 183,
Yeah, we can't really hear you. Sorry.
I'm sorry. I'm going to object, and we can approach if.
All right. All right, so, Ms. Love, my recollection is that the issue of the 17 plea, having been an Alfred plea, came up during your direct of, I don't feel like it was this witness. I feel like it was Mr. Sledge.
Because it was initially what happened is that
It's my memory that it did come up with this witness.
Also?
Yes, it was
Okay.
asked. by-
Okay. It originally came up with Mr. Sledge on your direct because you started reading a factual basis.
that's what I was about to say.
Okay.
So what I was about to say was initially it came up with Mr. Sledge
Yeah.
because of
Okay, we all remember why, but then how did it come up with this witness?
on cross-examination, the question was asked, if, I think something along the lines of, it, and it may have been by Mr. Adams, what is an Alfred plea? Do you do that because you feel it's in the best interest
Right.
of your client? And does that consist of certain things?
Okay.
And so because Mr. Adams got into the questioning of whether, what's an Alfred plea? What does it consist of? Why do you do it? And then there was, I believe, according to my notes, there was questions or there was testimony about Mr. Sledge's mother being ill
Right.
and him expressing stress over that.
Right.
My notes then,
I remember now. Thank you for recalling it to my recollection. So what is it that you want to ask?
at any time did he request that this plea be made simply in his client's best interest?
Okay.
Did his client ever request of the state to enter this plea in his best interest?
Okay.
And given that, of course, since now everybody knows that his client knows what an Alfred plea is, it's important that this plea and these statements weren't given or made simply because they were in his best interest.
Okay.
Understanding his testimony today, that wasn't something that was ever conveyed.
Okay, well, those two questions, did he at any time request it and did his client request it, seem like they would be appropriate. I don't know if you intended on some kind of third question or if that was just your argument, but did you intend a third question after those two?
No, my
Okay.
last question was intended to be, was this plea made under Alfred? Or was this plea, did your client ask us to allow him to make this plea under Alfred? So
Okay,
it's two
so we
questions,
know it
yes.
wasn't under Alfred.
Right.
So did he at any
Well-
time request that the plea be a best interest / Alfred plea, and did his client ever
We-
ask him?
We know, the jury doesn't know. That's why I was saying that. And I believe that it's,
Well, yeah, they do, because I instructed them already that for the one, they could not consider anything, and for this one, they could if they found inconsistent statements.
Okay.
So, yes, sir, Mr. Short. So as to those two questions,
I am not going to pretend that I was in the middle of their plea
hold,
negotiations.
hold that closer.
I am not going to pretend I was in the middle of their plea negotiations, but I feel that many of us know that the only individual that was allowed to plead guilty under Alfred is Mr. Sergio Kitchens, who had zero evidence against him, quite frankly. And so I don't think anyone would have perceived that as an option to even ask.
Okay, well, that's not an evidentiary objection.
Well, I would
Well-
object to those questions being asked because I believe any discussions that he would have had with his client about Alfred invades the province of the attorney-client relationship. Can he be asked whether or not the plea was entered under Alfred? Sure, that's how the plea was entered. But whether or not he had any discussions or whether his client asked him to approach the DA's office in regards to an Alfred plea, I believe invades the province of.
All right, if you
relationship.
if you were to make that objection, that would be sustained, but that objection would not be valid with regard to whether at any time Mr. Wright requested that the plea be permitted as a best interest plea. So you can ask that question.
Thank you. And Your Honor, as Mr. Wright has already testified that if his client asks for something from the state, he's obligated to convey it to the state. I don't believe that asking him whether.
All right, well, that's already before the jury, so.
Okay, thank you.
Okay, let's get Mr. Wright back in, and hopefully the jury will be ready to come on back in too. I wonder, I don't know whether he heard that or not. Can somebody see
want
whether
me to
the
get Mr.
jury's
Wright?
ready? No, I know that, the jury. Mr. Wright's on his way. Yeah.
Okay.
Is the jury ready? Great, they seem to be. Thank you. Go ahead, Ms. Love.
Thank you, Judge. Just two more questions. Certain that your client would have to testify
It was
on December 28, 2022?
correct. That the point was, if you need him and you want him to testify, he will. But it wasn't set in stone. It was going to be a game time decision once you made the decision.
And was your client served with a subpoena by the state on December 28, 2022 to testify in the trial of this case?
I don't know if he was served a subpoena that day. I mean, we were served a subpoena recently, and we've never taken issue with service or the fact that he will appear whenever the state wants him to appear. So we've never made issue of service.
And finally, you were asked on cross-examination about an Alfred plea, and it revolving around somebody saying they're not guilty. Was this one of those pleas?
This plea, no.
Thank you. That's all that I have.
All right, thank you. Is there any recross from any of the defense attorneys?
Mr. Stillwell.
No recross on behalf of Mr. Williams.
All right, thank you very much. Mr. Wright, thank you for your time.
Thank you, Judge.
And remember, your client is excused but not released, so if he comes back, we'll see you again, but otherwise.
Understood. Thank you, Judge.
All right, call your next witness.
Yes, Your Honor. The state calls Mr. Thomas Burnett to the stand.
Thank you.
I do. Absolutely. State and spell your first and last name for the court, please. Thomas Burnett. Oh, THOMAS BURNETTE.
Good afternoon, Mr. Burnett. How are you doing?
Hey, how are you?
Mr. Burnett, did you drive or fly here today?
Fly.
You're from another state?
Charlotte.
And what do you currently do for a living?
I'm a service consultant at an Infinity dealership in Charlotte.
And what was the first year that you began working for Infinity?
1997.
What did you do when you first began working for Infinity in 1997?
I was a valet. I was a valet while I was going through college.
And in that capacity, would you drive Infinity cars?
Yes.
After that, where did you end up? Did you ever end up getting a degree?
Yes.
Where did you get your degree?
DeVry University.
And what was your degree in?
Business administration.
Did you get that here in the state of Georgia?
Yes.
Now, after when you first were working as a valet, what was the next job that you had after getting your degree?
With Infinity or just the next job period?
Next job period.
I was in furniture sales.
What did you do after that?
I went back to Infinity.
What drew you back to Infinity? How did you end up back working for them?
Just a familiarity. I had a relationship with the manager at the store, and they kind of asked me to. It was opportunity, so I went back.
Now, when you went to Infinity this time, what was your job position?
Currently, what I do now, service consultant.
Now, can you explain for the jury what is a service consultant? What all do you do?
I meet with the clients or customers that come in for maintenance or repairs on their vehicle. I assess what the vehicle needs, whether it's check engine light on or a leak or no starting issue. I basically get the information from the client and put that in a manner so where the technicians can properly diagnose the vehicle. Once it's diagnosed, I reach out to the client and let them know what repairs are needed and gain the authorization to fix the car, and then basically handle the client throughout the process on updating them, let them know when the car is ready, payment, etc.
Now, as a service consultant, with what all you just described in terms of your job, what all you do in that job, do you have to have familiarity with the makes and models of Infinity?
Yes.
Can you explain for the jury how you gain familiarity with Infinity makes and models as a service consultant?
Well, we have to do certification tests quarterly to make sure we're certified, and then, also just being around the vehicles, you learn and pick up certain common things about the cars, and you have to identify certain things with them to know what year it is, what kind of type of oil it takes. So when you're quoting prices, you quote them accurately. So.
Now, as a service consultant, is your primary focus, is it true or false that you're focused on the clients that come in?
Mainly, yes. Yeah.
Now, to be an effective service consultant, with Infinity, do you have to understand the technician side of the business?
Yes, because I have to basically interpret as far as what the client is saying, as far as sometimes help the technician understand what the issue is. And then there's a lot of terms and expressions that technicians will explain to what's wrong with the car, and sometimes that's not customer friendly as far as to understand what actually the issue. So sometimes I have to do some interpretation as far as making it a little easier to understand on what actually is going on with the vehicle.
Now, Mr. Burnett, jumping back to after you got your degree and you worked in, when you first went back to Infinity, what location were you working out of?
South Atlanta, Infinity of South Atlanta.
Is that the one on 4201 Jonesboro Road?
Correct.
Now, what year was it that you?
2005.
And how long did you work at that location?
Till 2020, 2021, I'm sorry.
So roughly about 15 years?
Yes.
Now, over those 15 years, how often would you drive Infinity cars in any capacity?
Every day.
Would you drive them in both daylight and nighttime?
Yes, I currently own Infinity, and I've also owned Infinities from like 2007 on. So.
Do you get some perks working for Infinity in terms of owning an Infinity or buying one?
Yeah, we do get some discounts or considerations as far as what.
Now, what kind of vehicle do you currently drive?
Q50, Infinity Q50, a 2020 Infinity Q50.
Now, since you've been working for Infinity, when did the Infinity Q50 first come on the market?
2014.
Now, when it first came on the market, how would you describe an Infinity Q50?
It's a sports sedan built on performance. It was pretty unique in design as far as at the time, as far as it had distinct features as far as the headlights, tail lights, the front grille were pretty distinctive at the time when it first came out.
Now, is there any Infinity model or make that is similar back in 2014 when the Q50s first came on the market?
No, there was a G37 sedan, but it looked completely different than the Q50. It wasn't really, it was a whole different design. So
Now, is there any significance to the G37 in terms of the name of that car versus the Q50?
no.
In terms of the lettering or numbering?
Oh, well, like far as the G37 was basically named after the engine size. So the 37 is how Infinity used to distinguish what size engine was in the car. When the Q50 came out, it was the beginning of the rebadging to where all the same models basically had the same. So a Q50 is the sedan, the four-door sedan. A Q60 would be the two-door car, and then they identify the engine size by the decal that's on the side of the car, whether it's a 2.0 engine or 3.0 or 3.7 back when it first came out in 14.
Now, you have described a decal on the side of the Infinity Q50. Is that unique to that make and model?
Pretty unique. You don't see it a lot on other makes. You know, most makes don't identify what engine size is in the car by any type of badging on the side.
So previously, Infinity, you would know the engine size based on
The name.
yeah. And then after that, they put a visual indication of the engine size?
Correct. Yeah, they were kind of tired of changing names every time a new engine came out. So it went from like G35 to G37, and then it stopped, and then they just changed the badging on all the cars to Q.
That makes sense. Now, are all the makes and models in the Infinity fleet start with Q?
Correct. Yeah, the cars are Q, and then the SUVs are QX.
Now, you were working for Infinity in 2014 when the Q50 first came out.
Yes.
Has the Infinity Q50, does it have a sunroof?
Yes, pretty much probably 80% of the models, or maybe even higher, have a sunroof. The only ones that don't have a sunroof are the Q50As, and that's on the back of the car. You'll see the A, and that was kind of like the base entry level car, which we didn't sell very many of those cars because dealerships wouldn't order them because they knew they wouldn't sell them. So
now, when you said when you went back in 2005, you worked till 2020. What did you do after leaving the South Atlanta Infinity in 2020?
I moved to a few dealerships around. Initially, I took a job as a service manager at a Nissan store in LaGrange, Georgia. That didn't quite work out, so I worked at the Nissan in Morrow. Then I went back to Infinity, different location. I was at the Cobb County location in Nally. And then I worked for Lexus for a short period of time before the Infinity South Atlanta store asked me to come back. And that was in last year.
So you kind of went full circle back to that South Atlanta Infinity?
Yes.
How did that come about?
I was up there getting the oil change on my car, and the manager that was kind of like a consultant there at the time, he was just working part-time, he was retired. Him and the current manager asked if I was interested in coming back, because I had still a lot of clients that would come through the store asking for me and stuff. So they asked if I had any interest in coming back, and it lined up with what I needed at the time, so I went back.
Now, what do you like about working for Infinity over these years?
I like taking care of customers. Also like the product.
Sustain, hang on just a second. If you hear somebody say objection, will you just pause for a minute while I deal with that? Sustained.
Now, yes, Your Honor. Mr. Burnett, I'm going to show you what's been marked as State's Exhibit 459 Yankee and 459 Yankee Alpha. Your Honor, hand in the witness both 459 Yankee and 459 Yankee Alpha.
All right.
Mr. Burnett, what are 459 Yankee and 459 Yankee Alpha?
Both pictures of a Infiniti Q50.
How are you able to recognize them?
The shape of the vehicle, the headlights are pretty distinctive. The front grille and the tail lights are also pretty distinctive. And it also says Q50 on the back of the picture there as well too.
And for your testimony to the jury, would using 459 Yankee and 459 Yankee Alpha aid you in describing a Q50 for the jury? Aid your testimony?
Do you mean that he's helped with this?
Yes.
Yes.
Your Honor, at this time, the state is tendering 459 Yankee and 459 Yankee Alpha for demonstrative purposes.
All right. Those are admitted as demonstratives.
Publishing State's Exhibit 459 Yankee. Now, Mr. Burnett, earlier when you were describing a Q50, what is the most significant physical aspects of this make and model?
You mean like what makes it stand out the most?
Correct.
I'd probably say the headlights and the front grille.
Now, currently, so you've also had an Infiniti Q50, you said, since 2020?
Correct.
How has, since it came on the market in 2014 to present day, has the shape or the vehicle itself changed much?
Not much at all.
Overruled.
Now, Mr. Burnett, does your Infiniti Q50 2020 how does the front emblem look? Is it any different in terms of lighting?
There's some options on the newer versions of it, like 16 and up, where it lights up at night when the headlights are on.
Was that a feature when it first came on the market in 2014?
No.
Do you know when that lighting first came into the Infiniti fleet?
In 2016, when they changed the engine sizes in the car. It went from a 3.7 to either a 2.0 or a 3.0.
Now, is in 459 Yankee, are the rims on the tires, is that standard, not standard? How would you describe those?
Those are standard wheels on it. There's two options. There's the 19s and the 18s. And some have, it's three. So 17s, 18s, and 19s. Looking at it, those appear to be the 18-inch wheels that are on it.
Now, Mr. Burnett, earlier you'd mentioned about when Infiniti got away from naming the cars off the engine size, that they had a decal. Is that correct?
Correct.
Can you show the jury, if you see it, is that decal visible in 459 Yankee?
Yes. If you go just slightly back from the front wheel, you can see a silver kind of spot or kind of there. That's actually the decal that's on it.
Mr. Burnett, I'm gonna move this mouse. You tell me if I'm getting closer.
Keep going.
Okay. Same direction?
Yeah. You're right there at it now.
That is the decal that indicates the engine size?
That's correct.
Now, turning to 459 Yankee Alpha, can you describe for the jury what stands out to you in terms of it is different about the Infiniti Q50 compared to other Infiniti makes and models?
Just the shape of the tail lights are a little different than some of the other models are. They kind of mirror the headlights where they're kind of a little more kind of sunken into the body of the car.
And what, do you all have certain naming conventions for the colors that the cars may come in?
Yes. This particular color is diamond graphite.
Now, when did you leave what was your last job in the state of Georgia before you left?
I was service consultant at South Atlanta, the Jonesboro location.
And when you moved to North Carolina, did you work with an Infinity company
Yes,
there?
same role, yes. Just in Charlotte, yes.
Now, back in March of 2016, what location were you working in for Infinity?
Union City, the 4201 Jonesboro Road, Infinity of South Atlanta.
Now, do you recall a time where any law enforcement personnel ever came by that location when you were working to interact with you?
Vaguely. There was, and I don't remember the exact date or time, but there were some officers that came in. They were directed towards me. At the time, I was like the assistant manager or lane manager, sometimes we'll call it. And I think one of my other employees pointed in my direction. They had some photos or like a poster board of a car, and they just kind of asked some questions about what type of car it was. And there may have been a few other questions. I don't recall what they were. And then they were like, hey, this is part of an investigation. We'll probably be in contact at some point.
Sustained.
Now, Mr. Burnett, do you have any independent memory of what kind of car the vehicle was that they showed you in those photographs?
Not in 2016, no.
Okay. Now, I want to publish, Your Honor, what's already been admitted as 296 Yankee, and the state's going to start the publishing at 8 minutes and 30 seconds.
All right.
Mr. Burnett, while that's getting set up,
Oh, yeah, sorry.
in
Didn't know you.
preparation for your testimony, have you...
Hang on just a
sorry,
second.
Your Honor.
I don't see anybody waiting.
Have you, more recently than 2016, reviewed some surveillance video and photographs for your trial testimony?
Yes.
Your Honor, publishing State's Exhibit 296 Yankee at 8 minutes and 29 seconds.
All right.
Ms. Burnett, if you can, just watch this screen.
Okay.
Pausing. Now, Mr. Burnett was, I know that clip was quick. I'm going to publish 292 Yankee Hotel, which is already admitted. Now, is that surveillance video clip that you just watched, have you reviewed that before testifying in court here today?
Yes.
And what vehicle was depicted in 292 Yankee between 8 minutes and 30 seconds and 8 minutes and 40 seconds?
It was Infinity Q50.
Now, I'm going to, briefly on the screen, what's going to be published is 292 Yankee Hotel. Let me know when you can see that. Is this a still frame from the surveillance video that we just watched a moment ago?
No. Yes, it looks the same.
Now, can you describe for the jury what stood out to you about being able to identify this as an Infinity Q50?
The headlights, the way they appear, you also can see the black grille, and it's kind of hard on this one, but as it gets closer, you can see like a little bit of the logo like the silver reflecting in the front grill area.
And when you mean when it gets closer, you mean when
As it starts to come, I guess, closer to where it, before it goes off the screen.
published in Your Honor what's already been admitted as 292 Yankee Indigo. Now, Mr. Burnett, is this also I know it's currently blocked, but still framed from the surveillance video that we just watched?
Yeah, that still seems to be the same car, the Q50.
Now, what I'm going to do, Mr. Burnett, is I'm going to replay 292 Yankee at 8:30. You tell me when to stop when you had mentioned the silver emblem, right, as the car gets closer, in your words. So I'm going to play 292 Yankee starting at 8 minutes and 30 seconds, and you just tell me when to stop when you think it would be helpful to see that.
Sorry, it's real quick.
It's all right. I'm going to publish 292 Yankee Juliet. What's already been admitted as 292 Yankee Juliet.
You can almost see the reflection of it right in that screen there.
And when you had described, and by the reflection of it, do you mean, what do you mean by that?
It's almost like where I guess the lights or the street lights or whatever are reflecting off of it.
And
you can kind of, like if you look in between the headlights, you can see there's something there. It's not black like the rest of the grill is.
And you mean the front part of that Infiniti Q50?
Yeah, the logo that's in the front of it.
And when you had mentioned is this almost basically, when you said as the vehicle gets closer, as it's driving off screen, when you reviewed this surveillance video, is at what point from where the car currently is to when it's off screen did you notice that?
Originally, right, well, when you originally played it the very first time we spoke about it, I noticed it pretty quickly. Honestly, the very first time I looked at it, I was just looking at the car. I didn't even see what was going on in the side. And then the second time you read me back, I saw all the other stuff that was going on with it. So, I mean, as you recall, when I first saw it, I was like, well, that's a Q50. And you were like, how do you know that's a Q50? And we kind of went through the same. I was like, headlights, the grill, and same thing. And then also the tail lights, you can kind of see as it's taking off.
Now, thank you, Mr. Burnett. Now, since March of 2016, when law enforcement came and spoke to you, to present day today, do you have any other knowledge or information or any information about this case that this surveillance video is involved with?
No.
Mr. Burnett, I'm also going to publish 292 Yankee starting at 10 minutes and 40 seconds through 10 minutes and 47 seconds. It's gonna, it's close. Mr. Burnett, that surveillance video that we saw, have you seen that angle before?
Today, I saw it.
Okay. In preparation for
Right.
testifying. And in that, what car do you see in 296 Yankee between 10 minutes and 40 seconds until when we paused it at 10 minutes and 48 seconds?
It's the same car from before, it's just a different angle, it looks like. We're seeing more of the back end of it.
Earlier, you had mentioned the quarterly training that you've gotten since working in Infinity. Can you describe what that entails for the jury?
So anytime there's any new models or any new features or anything that's been added to the cars, they will have to go through certification tests on them. It could be modules to where we have to do like interactive videos and answer questions at the end, or it could just be an article that we have to review and then go back and answer questions. It just depends. Usually on a brand new model, it's more interactive stuff because they want to make sure that you're following along and know what's going on. You don't just skip straight to the test. But sometimes on some of the refresher stuff, like if it's just a specification change, like the engine size or new wheel package or something, it'll just be like some articles that we just read and then answer the questions based off of that.
One brief moment, Your Honor. Mr. Burnett, when the Infinity Q50 came out on the market, when was the first time that you drove it? Did you ever drive a 2014 Infinity Q50?
Yes, it was, besides customers coming in, we also had them as loaner cars. So that was one of our main cars we used as loaner vehicles. So we were constantly pulling them up, getting customers in and out of their stuff. Yes, I've driven them a lot of times.
And what aspect of the Infinity Q50 made you choose to buy it in 2020?
The size, the performance of it. It's a pretty fast vehicle. It has a lot of power. And from my standpoint, it's also pretty reliable because, I see what goes wrong and with them. So that's what kind of drew me to it.
Now, the dealerships or the locations you've worked at for Infinity, have those all been classified as dealerships?
Yes.
And is your customer either primarily or exclusively people buying a car for themselves? Or their, brief indulgence, Your Honor.
All right.
In terms of, do you have any familiarity with Infinity vehicles being sold to rental car companies?
So they would buy directly from, so they buy Hertz Enterprise, they buy directly from the manufacturer. Now we do see them when they come in for recalls and that sort of stuff. So they do bring or if there's warranty repairs that need to be done on them, Hertz Enterprise, they do bring cars to us for us to service. So, but like far as purchasing wise, they buy them directly from the manufacturer.
And Mr. Burnett, what is your favorite physical attribute of the 2014 Q50?
I'm going to object that to the relevance.
Sustained?
I would too, Your Honor. That's why I asked. With that said, Your Honor, the state does not have any more questions for Mr. Burnett. Thank you, sir.
All right, thank you. Are there any defense questions for this witness?
Yeah, sure. Yes.
Thank you.
Good afternoon.
Hey, how are you?
I'm good. I am fabulous. Fantastic. One of the last things you said was that the rental companies, I think Hertz you mentioned, sometimes brought their cars in to be serviced at the location that you worked at, correct?
Correct, because we were close by the airport, so we would get a lot of their cars brought in. So
Do you have any personal interaction with any car, any Q50 that would have been brought into your dealership back in January or February of 2015?
I wouldn't be able to recollect that.
And you would not have been the one to observe or look at or inspect any vehicles brought in from Hertz anyway, would you?
Only thing I would do was check it in, which basically would mean getting the mileage, VIN plate off of it, and doing like a walk around on it for damage. That would be my end as far as inspecting it.
Okay. But in 2015, was it 2015 or 16 when the Atlanta police came to talk to you about infinities?
I don't actually remember the exact date.
You have no real memory, no clear memory of when that was, right?
No, not the date, no.
Okay. Is it fair to say that when they came to see you, though, they didn't bring an actual vehicle with them for you to look at or offer your opinion on, right?
No, they were like photos.
They were photos.
Yeah.
The images that you just saw, right, and I'm going to ask the state's indulgence in a bit to put some of those back up again. You would agree with me, though, that those photos. All right, how about that?
We're good.
Those are black and white images, right?
What's that? The photos they brought in, or?
Yeah, well, no, the photos that you were just looking at and the video you just looked at, the still shot, and then the two videos, one of the car rolling forward from the front, the other one from the back.
Well, the photos here are color. The ones that they.
May I step up?
You may.
All right. Right, so these, and I'm going to reference for purpose of the record, 459 and 459A. These are the photographs that were presented to you from the state a little while ago, right?
Correct.
Right. Now, that's not what I'm talking about, though. I'm talking about the video that you were looking at, that the state played. Would you agree that was a black and white video?
I don't know if I would classify it as black and white. Now, it wasn't the greatest of quality of video, but I would say it was black and white.
Okay, let's look at it again. Tonight, would you be kind enough, please, to put up what the state has marked as 292YI, Yankee Indigo, like this. All right. Can you see what's on the screen in front of you, Mr. Burnett?
Yes.
All right. Now, you agree 292YI, that's the image that you looked at before, correct?
Yes.
All right. You're not able to tell what the color of that vehicle is, are you?
I can tell it's a grayish color. I mean, just like the car that's behind the white one appears to be like a reddish color.
Okay. So let's see. Are you going to tell me that that vehicle that you said is an Infiniti is a, what did you say it was a diamond graphite color vehicle?
Could I say it from the picture? No, I mean from this, no, I couldn't say it was diamond graphite, but I could say it's grayish in shade though.
Okay. You said that you recognize this as an Infiniti because of your familiarity with Infinitis, correct?
Correct.
Now, to be clear, you're not a scientific expert, right?
No.
You've never been qualified as an expert in Infinitis or identification of vehicles, true?
No scientist, no.
Okay. You've never been qualified in a court of law as an expert in identification of vehicles.
Never been to court before or anything for it, but as far as an expert in knowing Infinitis, I probably would say yes, I know all the models.
Okay. Tell me whether or not that vehicle that you're looking at, the one that you've identified as an Infiniti Q50, has standard size wheels or non-standard wheels on it as you described earlier.
We're talking about the screen, not the pictures, right?
So on the screen, yes.
I couldn't, you can barely see the wheels from this.
All right. Looking at that image that the state showed you that's on the screen right now, Tell me where you see on that there is an infinity emblem or insignia on the front grille.
This one doesn't capture it. He tried to roll it forward to where you could see that there is something silver in it, but technically they couldn't stop it at the right time.
Well, you said technically, but you don't see it at all, do you?
Not in this frame, no.
And in fact, when you were describing the image you said earlier, or you saw earlier, you said that you can, quote, almost see it. Remember saying that?
Correct.
All right. Looking at this vehicle on the screen, are you able to tell whether or not there's any damage to the front bumper or fender of that vehicle, as though it's been some sort of accident of some sort?
Not on the screen, no.
Are you able to see anyone, if there's anyone hanging out of the sunroof?
Not from this angle, no.
I'm curious, do you know whether or not the 2014 Infiniti Q50s have, I'm going to use OnStar, right? I don't know if there's another name for tracking.
It's Infinity Connect, yes.
Okay. That's a tracking system.
Correct.
Right. Do you know whether all of the Infiniti Q50s had tracking software in it that would allow you to track the car and tell you where the car is at a given time?
They have the capability, but there's a subscription that has to be paid for it to be able to do it.
Okay.
So if the subscription isn't paid, then it's not active for us where you could track it at the time.
Okay. You testified earlier, and I'm still referencing the image that's up on the screen, right? You testified earlier about there being an emblem on the side of the Infiniti Q50 that's a little bit behind the front wheel, right? You remember that testimony?
Yeah, but that was off of the picture though.
Okay, right. So putting the picture aside for right now and just looking at the image that was shown to you by the state, and this is the same image that was shown to you back in 2015, right?
No, they just had pictures. They had like pictures that came back in then. There was no videos or anything then.
Okay. So when APD came to see you in 2015, they didn't show you this video?
No.
Okay. So looking at the video that you're seeing right now, that you've identified, looking at that car, point out to me where that emblem on the side of the vehicle is that tells us it's an Infiniti.
You can't see it from this angle. Not on the video.
So I just want to make sure I'm clear and I understand your testimony correctly. 2015, APD comes to you and they show you some still shots of a vehicle.
Correct.
And they ask you to tell them whether or not it's an Infiniti or not.
They asked basically to identify what kind of vehicle it was.
Okay. And just so I'm clear, were the still shots that they showed you still shots from this video?
I honestly don't know where the pictures. I mean, that was 15, 16 when they came. I honestly don't know where they got the pictures from.
Okay. And they never told you, right?
No, they basically said that there may be some further questions they may ask and they'd be in contact, and that was that.
Okay. Was that the only time that they came to ask you anything about any Infinitis?
Yes, I didn't hear anything about it again until was it April or May? I think they reached out. I guess they still have my number on file from when initially I did the interview, and they called and asked if I remembered it. And I honestly didn't remember a whole lot of it at the time. As we talked further into it, some of it started to come back, but I didn't remember what kind of car was involved or any of that until I actually saw the video that they played for me.
And when you say they called you, are we talking about the DA's office or?
Yes.
All right. You didn't talk to anyone from the DA's office back in 2015, no, did you?
No, I would assume it was just a local police. They were in uniform, so.
Okay. A police officer?
Yes. Yes, the store or whatever. It looked like a store or something from what I could see.
Ms. Knight, would you be kind enough, please, to put up 292 YJ for me? Yes. It is a video, correct? Actually, no, it's not. I'm sorry. Let me correct that. That's 296Y at timestamp between 8:40 and 8:47. Let me correct that for the record. That's exhibit 292 Yankee Delta. I'm being told. Did you see the image that went across the screen there, Mr. Burnett?
Yes.
And can I have you run that one more time, please? Well, wait for that. Let me ask you a question.
Sure.
Would I be correct if I were to say that back in 2015, no one ever took you to an actual first location to look at any infinities?
No.
I think we're almost there with our image, Mr. Burnett. Mr. Burnett, I want you to pay attention to the image when it gets to between 8:40 to 8:47, okay?
Okay.
See that car driving past?
Yep.
So that is the car that you took a look at today. Today was the first day you saw this video, right?
This one, yes.
Okay. And then your testimony is that based on that vehicle passing by in the video between 8:40 and 8:47, you can recognize that as an Infiniti Q50. As an Infiniti Q50. Is that right?
Correct, yes.
And then would you agree with me though that even in that image, as it went by, you didn't see any Infiniti emblem on the side of it? Right?
No.
You didn't see an Infiniti emblem on the back of it, right?
No.
You didn't see anything that looked like damage to either the front or the fender or of the vehicle, right?
No.
You didn't see anybody hang out the sunroof or window, right?
No.
You saw the lights on the car,
Yes.
and you saw that it was a car.
Yes.
Thanks, sir. That's all.
Any other defense attorneys have questions for this witness? All right, is there any redirect?
Yes, Your Honor.
Go ahead.
Mr. Burnett, when law enforcement came to meet you, did they ask you if it was an Infiniti or ask you if it was what car it was that you were looking at?
They just asked me to identify the car, the vehicle.
And since you and I have spoken or met, have you always lived in a different state?
Yes.
And previously, were we able to speak or Zoom with one another? Is the first day you met in person when you flew into Navy?
Correct.
Ms. Burnett, I'm going to try to slow this video down. So the state's going to publish 292 Yankee Alpha. It's going to go at a slower pace, and if you see, Mr. Burnett, where you want to freeze it, where you can spot the emblem in the front grill, just let me know.
Okay.
So, Your Honor, for the purposes of the record, we're starting at 8 minutes and 32 seconds
Okay.
on 292 Yankee Alpha. Mr. Burnett, did that help any slowing it down, Mr. Burnett?
Not really.
That's fair. That's fair. Now, some of the questions, do you remember being on cross-examination, you were asked questions about, can you see the decal or can you tell about the tires? Do you recall that?
Yeah, what questions you just asked? Yes.
Yeah. And with this surveillance video that you've seen, is it that they don't exist or you're unable to give an answer on those questions because of the surveillance video?
They
Objection
exist, I'm
calls
just
for
not able-
speculation.
Overruled.
You may answer, Mr. Burnett.
Okay. Of course, the wheels and those things exist on it, and you know it's a Q50, so it's kind of hard to. Being that I know the vehicle, it's kind of hard to know. Okay, that's a Q50, and I know where everything is on it at. But trying to necessarily make it fit into the video where I can say stop right here, I see it. It's kind of a little hard to do in real time. And for the court's time, I don't know if we got this time to start just dissecting and stopping it every 2 seconds to see if we can get to there. But again, I've seen the pictures. I drive a Q50, so I know what actually is on the vehicle and where it's located at. But as far as using this quality of video, as far as to stop it, is kind of hard to do.
Thank you, Mr. Burnett. The state has no further questions for Mr. Burnett.
All right. Mr. Adams.
They may have a couple more questions for you, sir.
Oh, sorry.
They're almost done, but not quite.
So, Ms. Burnett,
Yes, sir.
so even though in the still shots and the videos that we've seen, right, we don't see the identifying item that you mentioned. We don't see a decal, right?
Not in the video, no.
We don't see the emblem on the Infinity emblem on the front.
Not in the video, no.
We We can't identify whether it's standard size wheels or whatever kind of wheels that you referenced before, right?
Not in the video, no, sir.
And so even though we can't see any of the things that you say would identify something as an infinity, your testimony is that you know that it's an infinity. Q50.
Right. So this is not the same car. Like
You tell me, is that the same car?
it looks like the same car in the video. It's a Q50.
May I?
You may.
So you're thinking that 459 and 459A, which has been given to you by the state, you believe that this is the same car that's been shown in that video?
The video is definitely a Q50. Yes.
Okay, you think it's this car?
It appears, as far as the color and everything else, appears to be, but
Does this?
again, these are all standard things. It's not like this is it has custom wheels on it or if it has a custom grille. Those are all the standard things that's on the car. So every Infiniti has the grille. I mean, has the logo on the grille. Every Infiniti has the badging on the side. Those are the standard headlights. Those are the standard tail lights.
Right.
So if it's a Q50, then it has those things.
So every Infiniti has that that emblem on the grill that we can't see on the video, right?
Q50, yes.
Every Q50 has that emblem on the side that we can't see on the video, right?
Correct.
Every Infiniti has maybe standard, maybe not standard wheels that we can't see on the video, right?
Correct.
But your testimony to this jury is that these pictures given to you by the state is the same vehicle that's on that video.
Correct.
All right, that's all.
All right, now you're free to go.
All right. Thank you.
All right, and it's just about 5 o'clock, so I think we'll break for the day. And I'm going to remind y'all, sometimes I give you a longer reminder, that you need to decide this case based only on the evidence that's admitted inside this courtroom. So please don't use the internet or any other source, electronic or otherwise, to get any kind of information about this case or about concepts in the law. Don't read, watch, listen to any accounts of this trial that might appear online, in print, on television, on the radio, or otherwise, including social media. Don't discuss the case with anybody or allow anybody to discuss it with you or around you, including don't discuss it amongst yourselves. Leave your notepads, notes in the jury room, and remember, for y'all tomorrow, it's a non-jury day. We'll be working, but we'll see y'all back Thursday morning at 9. Thank you. Okay, Miss Love, you had wanted to, I guess, tender for admission 452, 453, and 460Y.
So, Judge, they were all referenced, and by conditionally admit, what I was asking for permission to do, since they had all been identified by a witness as a particular thing and true and accurate reflections of them. And because they had been referenced so much during the testimony, my request was to tender or admit, rather, for as evidence 444Y, since 1AS
You
was
didn't
not.
even mention 444Y.
I didn't mention all of them that I wanted to. I started, but then when the court seemed inclined not to
Okay.
entertain that.
Deal with it right
Right,
then? Yeah,
right.
Since I didn't know what you were really
Right.
talking about in terms of conditional admission. Okay.
Right.
So 444Y is
Yes.
one of them.
So
Okay.
the state tenders a 444Y conditionally upon any redactions that we either agree on or the court simply instructs have to be made. 450Y, 451Y, just 452, 453, 454, and 456Y, as well as 460Y. And we have not tendered 463, which is the certified, which was used to refresh Mr. Wright's recollection. We're just adding that to the record because it was a document that had been referred to. So for conditional admission, we were tendering 454, 450. I'm sorry, 444Y, 450Y, 451Y, 452Y, 453Y, 454Y, 455Y, 456Y, and 460Y, to the extent that those reflect the emails from Mr. Wright to the state. So there
And
were,
then what about 463Y?
that was just the last.
Right, are you tendering that one?
No, I have
Okay.
it in my hand. I was about to hand it to Ms. Winfrey because it is a document that needs to go as part of the record, as something that was used to refresh the recollection. I had it, and while I had it, I just referred to it. It's not being tendered.
Okay.
It's just certified of Mr. Sledge's conviction.
Okay, and tell me what you mean by conditionally admit. Do you mean
I'm-
potentially redacted in some way?
Yes, I
Okay.
do.
All right. And are there objections to the admission of any of these in any form
All of them,
whatsoever?
all of them.
Okay. Yeah.
Now, if the point is they were referenced in testimony and therefore, for the purposes of the record, not to be
Well, I wouldn't consider that admitted.
right, but
I mean, I assume every exhibit that is utilized, whether tendered and admitted, tendered and excluded, or just used with a witness, is going to be a part of the record. Is that y'all's understanding as well?
yes.
Okay. So, in terms of admitting them,
So, okay. The emails,
yes.
450 was admitted, that was not.
Yes, 450 was, you're right.
the emails, we had lengthy discussions about the emails and about the objections and about the problems with some of the things that were discussed in the objections. Miss Love indicated that she wanted to talk about number 3, which seemed pertinent and wanted to get the wording exactly right. I had no problem with it. The other defense counsel didn't seem to have a problem with it, so we read exactly what the wording is. There's no need to admit that, and there's still problems with the other email, the other factual acknowledgments that are discussed in that email regarding the prior versions of the agreement. I went through great lengths to preview what I was going to ask so as not to open up any doors for quote-unquote statements that were never uttered or adopted by the witness to be admitted into evidence. The state is now asking the court to just admit documents into evidence that have those statements on it. Those statements provide nothing to the jurors. I don't know what conditionally means. I'm never going to agree to admitting things subject to redactions when I don't know what those redactions are. And it's completely unnecessary. We have read from the documents to get the words correct regarding specific things from those documents, specific acknowledgments from those documents, and both sides have done that. And that's what the testimony is. The proposed documentary evidence is full of inadmissible hearsay and other things, and also provides nothing to the jury at this point. So I, on behalf of Mr. Stillwell, I should say, oppose the admission of any of those documents into evidence at this time.
On behalf of Mr. Williams, I'm going to join in Mr. Short's response. We've already objected to the admission of any of those documents, and we would, I also do not know what a conditional admission of evidence is,
Well,
so
I
I'd
guess-
oppose.
Right, so I guess she means she wants to, if possible, be able to come to agreement about redactions of them, and if not, then present them to the court with her proposed redactions, which, I mean, maybe y'all can get together, and since we have a non-jury day tomorrow, we can deal with that tomorrow, but I don't mean y'all figure out what the potential redactions are tomorrow. I mean, have something ready to present.
Yes, and so, Your Honor, inasmuch as the tendering was done today, I'll withdraw that request until I have a redacted version to show counsel for defendants into the court.
Okay.
And the court had it exactly right. It was until there was either an agreement or something that the court
Or then you
deemed-
can present it to me and I'll make a decision.
Yes.
Okay. All right, well then have those ready first thing in the morning.
We will, along with the other additional emails that the court told me to have.
Right, for me, for an in-camera inspection. And then I would like for us tomorrow, I know that a couple of people have forwarded some things for our task list for tomorrow. There's a motion in limine filed by Mr. Ryan about autopsy photos. There is a motion in limine by Mr. Williams that provides some law and argument on an issue that we had raised our last non-jury week but not decided about. I can't remember whose statements they were, but some of the wiretap statements we'd kind of gotten partway through and gotten, I think it's fair to say, probably bogged down on one particular call and whether there's hearsay within hearsay and whether it qualifies under 801 D2E. So we'll circle back on that issue and maybe make our way a little bit more through that. And then I would like for us to at least start on what's everybody's understanding of which exhibits have been admitted and which haven't, kind of what the status is of the exhibits so far. I covered everything that anybody's forwarded. Is there anything else? There might be.
I haven't yet seen, but I know that they probably are in my inbox, so we'll, since we should be, I guess, ready to respond to the motions in limine, if they're new,
Well, the one of them I think is new about the autopsy photos. The other one's kind of just a follow-up on some law. Yes, sir.
And we filed a brief on that yesterday, I believe.
on what?
So I just want to make sure that
Maybe that's
you.
what I'm thinking of. Is the Williams motion limine separate than the Mr. Nichols brief
Yes.
on that?
Yes.
Two separate issues,
Yes.
or the same issue?
I did not repeat what the Honorable Mr.
But
Nichols'
it's in
lawyers.
the same topic?
Yes.
Okay,
I just added
All right.
other law.
all right. All right. And honestly, that'll probably carry us through the day. We probably won't even get through all of it. Any other topics or items we need to be thinking about?
Could the court just inquire who's the next several witnesses? It got kind of,
Sure.
I know it's a witness issue, I was told.
Yeah, so Thursday and Friday, who do y'all anticipate your witnesses being?
Second, let me get that list. Officer Adrian Pitts. Miss Sharon Latners. Potentially crime scene tech Turner, Miss Denise Bell, Officer Sean Hill.
Turner Bell and who?
Hill.
Hill?
Officer Sean Hill.
Okay. All right.
Crime scene tech Jenkins, Detective Thorpe.
Okay. That, we won't get through all of those in 2 days, so that'll give y'all the list of the next several. All right.
And the one main one, if we, the one that has.
It's just the gremlins that are apparently in residence here in 1C. That one doesn't seem to be working at all. We may need to put new batteries in some of these.
If another witness that we had on our list is available, that we had mentioned last week, that we had approached the bench about regarding a condition that they had, a lay witness.
I can't remember. Do they know who you're talking about? I can't remember. Do y'all know who we're?
Your Honor, I'm going to withdraw that. We'll leave it at where we have it right now.
Okay.
I'll speak to anybody who asks about
Okay.
that, but we're
Mr.
good.
Weinstein, you seem to want to say something.
Normally it's that I have to use the restroom, but actually it's on a different subject matter.
All right.
Just briefly, I'm not going to be here, Your Honor, tomorrow. Ms. Hingerty is.
Okay.
But I guess I'm going to go back to the old saw that I keep bringing up, Your Honor. And just briefly, just give me 1 minute.
Okay.
1 minute. I'm going to renew my motion for the court to limit the state's time. I'm going to cite your authority under 244403, 246611, and I'm just going to ask you, please read, if you haven't already, U.S. v. Reeves.
I've read it.
I think it's very persuasive on your ability and the logic and reasoning behind putting a time limit on the state. We just got through with a witness, Your Honor, that the state said was going to take 3 hours. And we spent, now that was just 3 hours on direct. And we just spent a week on that witness, Your Honor.
Well, we had 2 witnesses this week.
5 days, and then, yes, Your Honor, I'm not going to disagree
Well,
with you.
wait, no, this is only, what
When
is today? This is only Tuesday.
It was Tuesday, I think it was Tuesday, Wednesday, Thursday, Friday, and then Monday. But whatever, it was far, far longer than 3 hours. So please look at Reeves again and consider it, Your Honor.
So, I am reticent to say, for this witness, you can only have X amount of time.
No, I'm asking for...
However, okay, we've got a, how many count indictment here? With at least 8, in addition to the Rico count, 8 different sets of crimes. And the case law also provides that the state is entitled to, and it is, a violation to prevent them from being able to present their case. And I know that's not what you're asking, but how am I to know how long it is going to take them to efficiently present the amount of evidence to cover all of the things that are in this indictment? That being said, I will say that not so much, honestly, even the amount of time that was taken up with Mr. Sledge, because I assume the 3-hour estimate was thinking Mr. Sledge was going to be a cooperative witness, and Mr. Sledge didn't ultimately end up being so much of a cooperative witness. But y'all, I mean, the amount of time that was taken up by everybody with Mr. Wright was probably a bit excessive, and I put everybody who asked questions almost in that category. I do think that the state needs to, I don't know, get more targeted and focused with the examinations, and then there seems to be redirects take almost as long as the directs, and that should not usually be the case. And nobody ought to be rehashing things that have already been established, either at, I mean, a little bit of leeway every once in a while to, okay, let me refamiliarize you to this as I lead into what I want to get to. But like a 5-question, you know, there's this, there's that, there's the other that everybody's already heard, and I'm addressing this to everybody who might need to hear it. That we don't need. And we just don't need to be rehashing everything. And we also need to think redirect is supposed to only cover things that are in cross, and recross is only supposed to cover things that were in redirect. So please get more focused, and to the extent that people make the 403 waste of time objection, I'm going to take it seriously.
Well, you know, I think Reeves addresses, I guess, a lot of that and the need for us to raise 403 by eliminating that and eliminating the courts, or reducing, according to the judge in that case, you know, eliminating the need for the court to spend a lot of time on 403s, because it forces the state to be more efficient in their presentation of the case. And to say that the state is moving with any degree of efficiency or I just don't know what to say about the plotting rate that the state plows through the direct examination. And I don't see anything. I mean, we're 100 witnesses in. We got 100 witnesses to go. I know that's a rough number.
I'm hoping we don't actually have 100 witnesses to go.
Well, that seems
I really
to be a
would
bottom.
like that to be narrowed down, but I don't think we've gotten to the point yet where we can turn to that topic. But I mean, I've said a couple of times that the state needs to take a very close and careful look at the witness list that still exists and do everything you can to make sure that we're not being cumulative with our witnesses. And I hear you saying maybe we should be doing the same thing about a time limit. And y'all, I mean, you know, and I know it's not a trial, but incredibly important issues get decided in appellate courts all the time. You get, 20 minutes to talk about something that could be groundbreakingly different. So, I'm not saying that at some point I might not just say, all right, you've got 5 hours for this witness's direct and you can do it in that amount of time. I'll need to know more about what you need to cover with that witness, but it's not outside the realm of possibility. I do think that given how long Mr. Copen was on the stand, that we've made real progress in that we've now been able to finish 2 witnesses in far less time than that. But I hope 3 witnesses in far less time than that. So I feel like it is progress, but we could probably get more targeted than we are.
Okay.
So
in as much as this, I'm probably the most verbose of us all, but I can make my questions tighter.
Okay.
The intent on redirect has always been to respond to things that I hear brought up on cross, and to the extent that I can be more precise in pointing out the specific question that was raised on cross that I'm trying now to have the witness explain further or give an explanation for, I will do that as well.
All right, and I do not want to call anybody out in front of the jury. I also don't want to excuse the jury constantly. That takes a lot of time just for them to even file in there and file back. So, you know, I'm telling y'all this now in the strong hope that what you're saying you're going to do, you're actually going to do. But if I see that it still is as, I don't know the right words, but depending upon what I see, I may have to deal with it further.
Okay, thank you, Your Honor. And I wouldn't keep raising this if my client wasn't stuck at Rice Street. So that's the reason I bring this up every once in a
Well,
while.
I mean, I think it's fair to bring up
Thank you.
regardless.
Thank you, Your Honor.
So-
I appreciate you hearing me
Okay.
out.
And Your Honor, I also, just for the record, and so that the victims that are named in our cases are aware, we are appreciative of the courts affording the state the opportunity to effectively present to the jury all the evidence that we have in this case without being cumulative and without being redundant. But our victims obviously deserve every bit of attention that we have to offer to this, and I appreciate the court's willingness to afford that to the state.
Okay. All right, if there's nothing else, then let's convene at 9 tomorrow.
Thank you, Judge.